What about 33? We have a received any
33 CD received.
33 with 34. You are on 33 only. Both the cases are 33 and 34 are connected.
CD received.
34, some other councils are there.
34 also.
Oh, you are being 34 also. Both 33 and 34. Request for you, number order eligible. Here we have received the case diary.
Case diary.
We want to retain it or what?
Retain CD.
Are you on interim there? In both the matters, you are on interim. So CDB return otherwise. Yes, May month of election. May month of May.
9.
We are listing it on 9/5. We are returning case diary. Interim will be extended till next date of CDB return. Call for an update.
May please, Your Lordship.
Yes.
Lordship, item number 35, Lordship. The last occasion CD was called for. The CD is
CD
not received,
not
Lordship.
received.
So, Lordship, maybe based on the unification, Lordship.
Are you on interim there?
Yes, Lordship.
You are on interim.
Yes, Lordship.
Interim be extended till next date closing. Issue reminder for CD. List accordingly. Yes, when it can be listed. 29th of February.
All right.
May it please your lordship, I beg to mention for listing of a bail application tomorrow, lordship.
Make a mention before court number 3.
Lordship, matter pertaining to same FIR.
Court number 3, you make a mention before court number 3. It will be listed before this. Make a mention.
Lordship, in item number 35, charge sheet submitted also. That's now we mentioned.
Yeah, how would it? Let it be.
Yes, sir.
May I please, Your Lordship? I became item number 40, madam. I am on
40.
interim, madam. Yes, 40, madam. I am interim case that has not been
CD
received.
not received, lordship.
After vacation,
29,
Interim be extended. 29th.
there is an interim, madam.
Interim be continued.
Yes,
Yes,
Lordship.
Mr. Lord. My lord, I beg to mention item number 13, my lord.
1-3
This is 13, 1-3. Additional affidavit is filed today, my lord. Kindly bring in.
for 1-3.
1-3. Obliged.
May it please your lordship. Lordship, I beg to mention item number 8, 12 and item number 18. Lordship, kindly fix this
Item
matter.
number 8.
8, 12 and 18. Lordship, kindly fix this matter after Bihu vacation. All these 3 matters are commercial quantity charge sheet at the NDPS
After Bihu.
after Bihu. Lordship.
Yes, when it can be fixed. After Bihu will do. Okay, after Bihu.
Obliged, Lordship.
May I please, Lordship?
After
I beg
Bihu, go take it.
I beg to mention item number 47, my lord.
8, 12.
47. 89.
Yes.
Item number 47, my lord.
40.
47, my lord. This matter may be adjourned only for the day. From daily list.
CD is there, 47.
It is
47 CD is there.
Till 22nd of April, can it be? 22nd of April. Are you on interim?
interim, madam.
24. 24. Okay, 24.
24 will be difficult, madam.
You're difficult on your part.
25, madam.
25. Okay, then.
All right.
25 for interim be continued till next. CD, are you going to retain the case diary here? Thus? Or
Return, lord.
you can be
Retain.
okay. CD be retained till next year.
The 47 CD is done.
Item 1.
May it please the lordship. Contraband in question is commercial quantity. Lordship may call for the CD fixing 29th lordship.
It is charge seated? No, not 29 for.
29th. CD lordship.
Yes. Possible. Possible. Oh,
And the
Item 2.
Wait, please, your lordship.
item 2 on office notice there. No?
Your lordship. Your lordship,
You have already filed an additional.
Yes, Your Lordship. In the earlier order, Your Lordship has directed us to file the searches by way of an additional affidavit. We have filed the additional affidavit now, Your Lordship. Now I pray before the Honorable Court to issue notice against the respondent, Your Lordship. This is a matter related to POCSO, Your Lordship.
heard Mr. You are Mr.
I-
Hussain, heard Mr. I Hussain. And also heard MS and Endas. Endas, you are Endas, no? Ah, Endas, Learned Council, Learned Additional PP. In pursuant to order dated, last order. 25/3/2020. No, 21/3/2025. The additional affidavit has already been filed by the petitioner. Do notice queryable to the respond number 2 through the additional police station, deputy officer of dispatch. List, here it is a charge sheeted one or not yet? Charge sheeted case. It will be after Bihu only, yeah?
The date may be given you.
24.
Huh?
24.
24/4.
Can it be on 22, Your Lordship?
22.
22 many matters. 22 many matters, 24.
Sorry.
20.
Item 3,
Okay, Your Lordship. Your Lordship, this is a bail application. File and the sections are 8 subclause of the NDPS Act, 20D, subclause 2C, 21C, under the NDPS Act.
It's a commercial quantity. Yes, we are calling for the case diary. Are you have filed any objection here?
No, Lordship.
You're going to file?
We're going to file, Lordship.
CD call corridor. Fix a month. The
Short date may be-
respondent side also will be at liberty to file their written objection if any. Is a charge sheeted one? Not yet,
Not, sir. She said
not
not.
charge sheeted. Your petitioner is behind the bar since when?
Shit. 24/12/2024, Your Lordship.
24. Well, it will be on April, otherwise we don't have any date. April, no, we
After
don't have
Bihu
any
also.
shorter after Bihu. 29/4.
29. Oblige, Your Lordship.
Oblige, Lordship.
item 4,
Your Lordship, kindly pass over the method for some time, Lordship.
Timing.
Some time, Lordship.
5,
Yes.
In this case, out of same FIR and same boarding report, Lordship, the another petition is pending on 9/4, Lordship. And BA number 826/2025.
BA number
826/2025.
25.
On 9/4/2025.
No, 9 we are won't say, like we list along with her. List the matter along with BA 826/2025. Okay.
Fixed on 9/4/2025.
No, that I cannot say. We will fix it on. Well, let's fix it.
Oblige.
item 6,
May I please, Your Lordship? For the free application, arrested on 18/3/25, my lord. At this case diary now. Can be on 9th, my lord,
No,
after a week,
no, we don't have.
before vacation, my lord.
We don't have any date.
Reopening date.
My lord can be on 11th, my lord, last day.
We don't have any.
From Sansari only, my lord. It was,
No, the Sangsari is different thing, but
I know.
we may be on leave on 11.
my lord.
Probability is there, may not be also,
Yeah.
because morning also we are leaving actually. Leaving for Hyderabad and so we are listing list numbers of matters on 11,
My lord.
probably, that's why.
My lord,
22.
can it be on 21st then, my lord? On
22.
reappointment,
21st, many matters, okay, then we are fixing on 21st.
my lord. Oblige, ma'am.
CD not received. CD call for her.
May I please, Your Lordship. Lordship, in this case, my senior will appear, Lordship. Kindly pass over for time being, Lordship. He is coming, Lordship. Deeply, Your Lordship.
Motion matters are over, Nikki. Motion is almost over.
One timing there.
No. 7 is also timing. And 1-4 is timing. Huh?
City is there, Lordship, but it's seven.
In motion matters. Actually, it should be in hearing column, in fact.
Okay, earlier it was listed before the report number 3, Lordship, and status report was called for, Lordship.
Oh, that
So
has
it is
already
wrongly,
received.
Lordship, listed in motion column.
Pardon?
Wrongly listed in motion column, Lordship.
Actually, that's what.
Lordship.
If I percent will have 8 number 8 dot. No, number 8 no, number 9, 8. Is it 9 boy? 8 to one affidavit আছে. Oh, after bihu na. 9 affidavit ahi গেছে. আচ্ছা.
For bail hearing, item 9.
You have filed one affidavit.
Yes, Lord.
It has received.
Lordship, this is the 483 application under BNSS,
Hmm.
paying for regular bail. The petitioner was arrested on 27/2023 and has been languishing behind prison for 623 days.
He was arrested on when? You are 20,
27/23/07,
2007, 23.
23.
Acha.
And it's been 623 days today,
6.
23 days.
Hmm.
Lordship, I would like to take you to the additional affidavit we had filed yesterday. And we have annexed the notice of section 50 as annexure 6. If your lordship goes through the notice, there is no ground of arrest which was notified to the accused petitioner in the notice served to him under section 50, and no due notice was served to his representative under section 50A of CRPC, as mandated by CRPC, as well as section article 22(1) of the Constitution of India. And your lordship has recently dealt with a lot of cases on this point of ground of arrest, and lordship has
But
looked up.
do you have with you the certified copy? It's not certified copy. We need this one. Otherwise, we don't have anything before us, actually. We have anything? We have the
It's a
CD.
charge sheet case of it. It's a charge sheet case.
Oh, CD of
Yes.
case die? Okay. You can see from there. You have
There
got.
is no ground of arrest. So the arrest itself is illegal. That's what the lordship has already laid down the law in many cases recently. And I pray your lordship that the bail may be granted. Solely on this point that there is no ground of arrest. Only
Otherwise, what is the stage of Mr. Borwa?
It says, my lord, on 23/4/2024, my lord, search frame, my lord,
23-4,
4, my lord,
charge frame.
search frame. After that, probably no witnesses examined, my lord. And it's a commercial quantity, my lord. There are 5 accused persons, my lord. All possess, my lord, the contraband, my lord. Total amounting to 33 kg, 560 gram.
Total 5.
33 kg, 560 gram. All total, my lord.
lordship. In reply to that, I have a reply.
Just a second. So recovery is there. Now, no witnesses examined till date. And
That is
the charge framed on 23rd of
23/4.
Accused of man. Lordship, when the charge was framed, section 29 of NDPS was not included, which is the conspiracy part of the
29 was on.
not included.
What is this charge frame?
Charge, so my petitioner was only carrying 2 kgs.
No, whatever charge is framed under section.
It is not, only the conspiracy section is not there, but they have carried it on
20
22
B to C, my lord.
BTC.
20,
B to C. 20 B to C.
But
20
29 was
BTC.
not incorporated,
Page
which is
35 of the bail application.
which is the conspiracy part of the, and if there is no conspiracy, then it will be only amounting to 2 kgs, which is not commercial quantity.
you do one thing. I'll give you dictation part dictation. The rest of our observation is there in other cases. So we'll provide it. Karon bahut matters ase agli bas. You call it So first of in window. Heard you are Mr.
MS Hussain.
Heard Mr. MS Hussain, the learned counsel for the petitioner. And also heard Mr. R.J. Borwa, the learned additional PP appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. Scanned copy of the case record has already been received. There is the same. Next, paragraph is submitted, and the one additional affidavit is also filed by the petitioner side, which is already tagged with the case record. It is submitted by Mr. Hussain that the accused petitioner was arrested on 20/07/2023 and feel that he is behind the bar for last 623 days. Uh, the it is alleged that the 2 kgs of ganja,
2 kg.
2 kgs of ganja was recovered from the possession of the present petition. And there is no adding of section 29 NDPS Act, though charge is framed under section 22 small b, small Roman 2, capital C NDPS. Further, he submitted that till date, no witnesses could be examined by the prosecution. And apart from that, he raised the issue that there is no ground of arrest was mentioned in the notice issued under section 50 CRPC 50 and NDPS or CRPC 50 CRPC, no?
CRTC.
50 CRPC to the accused petitioner, nor his family members were intimated or not intimated through any notice under section 50A CRPC, which is mandatorily required for mandatorily required, and thus the notices were served violating the provision under section 50/50A CRPC, which otherwise violates the constitutional right of the present petitioner under Article 21/22, subsection 1 of the Constitution. And next paragraph, further he submitted that considering further he submitted that considering this aspect of the case vis-a-vis the period of long incarceration, the accused petitioner may be released on bail. He is ready to provide genuine surety and will abide by all terms and conditions imposed on him, and will also appear before the learned trial court below as and when the date is fixed. Next paragraph. Mr. Borwa, the learned additional PP, submitted in this regard that the recovery was there from all the accused persons, and charge is already framed on 23/4/2024. However, till 24, however, till that no witnesses could be examined by the prosecution, and the court is taking regular steps for procuring the attendance of the witnesses. He further submitted that this is a case of commercial quantity, and about 33 kgs 560 gram of cannabis was recovered from the possession of the accused persons, and finding sufficient prima facie material, the charge sheet was framed, and charge was also read over and explained to the accused persons. He further submitted that being a case of commercial quantity, the rigor of section 37 will also follow in this case, and he raised objection in allowing the present petitioners to go on bail at this stage. Officer observation in there only the indirect. Okay, we'll pass the order.
Much obliged.
Double.
May it please, your lordship.
Yes,
Lordship, the accused person was arrested on 3/11/2024.
311.
2024.
Mm.
And the accused person is the local person, your lordship. And he is in custody 121 days.
311.
121 days.
121 days. Yes.
And your lordship, FIR is page number 12.
Today on 2/11/24 at 2:40 PM, and information from a secret search was received regarding dealing and selling of illegal drugs by culprits of Hengrabari area under dispute PS jurisdiction since long. Accordingly, informed the matter to the senior.
Can you tell us the gist of the FIR because it's a long FIR, yes?
Yes, Lordship, but the recovery since is your Lordship on page number 13.
Hmm.
13 of the second para.
Hmm.
The said recovered suspected heroin recovered from the body position of the apprehended person Bhaskar Kolita were taken weight in the digital machine, and weight was found to be 33.84 grams of heroin. Means your Lordship, this is the B category. 33.84 grams.
Hmm.
And the last para, your Lordship, during her house search, 86 numbers of colored SPM PRX capsules, 21 numbers of blue color tablets having total weight 80 grams suspected to be containing contraband psychotropic substances, tramadol, kept concealed in a white color polythene. It is recovered from the house residence, not from his body, your Lordship. And the ganja was recovered on the page number 14. Ganja was found to be 645 grams only, your Lordship. And 645 grams is the air category, your Lordship. And where is the tablet is mentioned, your Lordship? That tablet is recovered from the residence, your Lordship, not from his body, your Lordship. So not from his possession. And Lordship, he is in custody 121 days. And Lordship, section 173 clause 2 of the CRPC. However, unnecessary delay is still not imputed as they are important to prove the case of prosecution, your Lordship. So forensics is no need for waiting for your Lordship. Already we have waited since 121 days, your Lordship. And he is the person is the local person, your Lordship. Kindly bail may be allowed in any condition, your Lordship. And here have no chance for absconding. We are faced to trial, your Lordship. Yes, Lordship.
Yes.
From the body search, Lordship, 33.84 grams were found. And in his car, Lordship, 105 grams of heroin is found. So 138.84 grams. It is intermediate. However, then Lordship, in his house search, 80 grams of tramadol. It is also intermediate, Lordship. And moreover, ganja is also found 645 grams. So Lordship, possession is there. And independent witnesses are also there, Lordship. They have implicated him. Moreover, Lordship, FSL, we have
Commercial quantity is, what is the commercial quantity?
commercial quantity is 250 grams of tramadol.
Tramadol.
Tramadol in heroin
It
also,
is
Lordship,
intermediate
250.
quantity. And already 121 days.
Ganja is small quantity,
Small quantity, yes.
645
Right.
grams.
Yes, Lordship. Already 121 days in custody.
And here we
Wait a second, let him submit.
have not found any FSL report, Lordship.
Lordship.
Oh, why 21C is registered? Case is registered under 21C. Na?
Mistakenly, it has been registered by the police.
22 is for tramadol, I think.
Mhm.
That's 21C is there, is for heroin.
Is there, Lord.
And the rest is for the cannabis. Just see. Where is the seizure?
Lordship, seizure is here.
Is there any observation from the code below? What was the quantity without bail, what about?
Lordship, one. Correctness of the 52A, the order is there, Lordship.
See that in that order.
Weight is 106 gram approx, inclusive of the weight. How much is that now? Lordship, kindly grant me some time, Lordship.
Yes,
First,
go
I
through,
will
go
go through it, Lordship.
Because it is already registered.
Yes,
That's why it is registered. For just for time being, he will see it.
Okay.
13,
Affidavit and.
Well, in this case, my lord, today I have filed additional affidavit. And this is.
No, no, we are going to please, 13. You have filed one additional affidavit,
Yes,
no?
this
It
is
has,
one.
we have not received.
Yes, this one copy. That,
You have you received?
yes, this another copy.
Same formula.
Same formula and two pleas
Same
I have
formula.
taken here, my lord. One is that formula, my lord, arrest procedure. Another is I am protected under two judgment. Nothing recovered from me. I have been implicated at the poetic statement. An arrest procedure, my lord.
One, you have annexed one arrest memo and
Arrest memo, notice under section 50 CRPC. And the most surprising is that, my lord, the BNSS came into existence from 1/7/2024.
Mhm.
Wherein 14/7/2024, notice under section 50 CRPC is provided. So much CRPC is not exist at that particular point of time. So, and also.
and that apart from your side, there is no recovery.
Not in recovery level. I protected under Bihans Kumar and Tufan Singh. And I'd like to place another judgment of our our coordinate bench, Midas. This is Jasiruddin Gorgoya, Bihans Kumar. And. Tufan Singh.
Since how long he is in custody?
I have been custody, Midas, since 14/7/2024. Today is almost 10 months, 9 months.
That's what the last report, my lord, the case was fixed for, my lord, 4 copies, my lord. Charge was not 7. But my lord, if 47, my lord, that 50 comes, my lord.
And CRPC not exist at that time, either.
Otherwise, it's of commercial quantity.
Otherwise commercial fund.
It was on the basis of co-accused statement.
During interrogation. So arrest procedure, nothing followed, madam, this call. And the one single.
That apart from the-
My submission may be recorded.
Yes, I'm recording. Heard Mr. H.R. Sodri, the learned counsel for the petitioner. And also heard Mr. R.J. Borwa, the learned additional PP, appearing on behalf of state respondent. Scan copy of the case record had also been received. Further, the petitioner has also filed one additional affidavit to bring the address memo and the notice under section 50 CRPC into the record. Next para, it is submitted by Mr. Chaudhary, the counsel for the petition, that present petitioner is innocent and he is no way connected in the alleged offense. No recovery, full stop, no recovery was made from the person of the present accused petitioner, and he was arrested only on the statement made by the co-accused under section 67 CRPC, which is not tenable in the eye of law as per ratio laid down by the Honorable Apex Court in case of Tufan Singh. Tufan Singh, bracket or supra-legal. Further, Mr. Chaudhary submitted an expert that the arrest is also illegal as there is no mention of ground of arrest, neither in the arrest memo nor in the notice issued to the accused petitioner under section 50 CRPC, which violated the provision of section 20 section 21/20 2A1 of the Constitution of India. In this regard, he also relied on a decision of the Honorable Apex Court passed in case of Bihan Kumar. He reported five so and so corridor. I'll give the other part is there with me. In preliminary, we have this. Rest you can skip from there only. Bihan Kumar as well as one decision of this coordinate bench. Passed in bail application number 3081 of the 2024. Next para. Mr. Borwa, the learned additional PP submitted in this regard that there are sufficient implementing measures so far collected by the IO, and on the basis of which the charge it has already been filed against the present accused petitioner. However, till date, the charge could not be framed by the learned trial court below. However, he submitted that the case is of commercial quantity, and hence the report of section 37 will follow. And there is, and on perusal of the record, it is seen that there is no material to held that this petitioner is innocent, or he will not commit similar kind of offense while is on bail, which is the as per requirement of twin conditions under section 37 NDPS Act. Please, episode. Okay, we'll continue.
P.
Yes.
Spoxo case, my service is not complete, man.
Lordship, is a charge sheeted case and the trial has started. When the case is pending before the special judge Patsa Masal, Lordship.
One report we have received, I think.
I could not go to the record, my lord.
The services seems to be completed, but he is remain unrepresented.
My lord. Then my lord, amicus may be appointed.
But it will go after Bihu then.
Amicus will service complete.
We're going to appoint amicus today itself. But we have received the case record here. Case record is received. Then when it can be fixed?
24 now, or 28,
24.
24 or 28.
24 many matters.
30, my lord.
25 can be around. Hard MS,
R call.
R called the counsel for the petitioner, learned counsel for the petition. And also heard Mr. R.J. Bulwa, the learned additional PP, appearing on behalf of state respondent. As per office note and the report, it is seen that this notice is duly served on the respondent number 2. However, no one has represented the respondent, and accordingly, it is felt necessary to appoint an amicus to represent to respond number 2. I am not finding. Yes. Can you suggest a name? M.K. Brown. Accordingly, MS M.K. Brown be appointed as an amicus to represent the so and so. As for number 2, registry will do the needful.
25 for me.
List a matter accordingly on the 25/4/2030.
15,
Yes.
Sir, please, Your Honor. My senior is in lag on another court, so matter may be taken up after break.
Lordship, kindly adjourn the matter for a day, Lordship. There's some difficulty, Lordship.
We have some difficulty on your part.
Lordship,
You have some difficulty on your part.
Lordship.
The question, if matter adjourned, then it will be after Bihu only, not prior to Bihu. You can ask your senior otherwise, because they are praying for an adjournment. Just make a confirmation with your senior, then it will go after Bihu, because he has some difficulty. Have you filed your objection here?
Lordship. No, Lordship. We
have not filed.
objection, Lordship.
Kindly direct them to file objection, Your Honor.
At a request made by the learned counsel appearing on behalf of standing counsel NCB. Matter be listed. Detail is 28 na? 30. 30. 30 will do. 30/2030 2004/2025. And in the meantime, the respondent may file their written objection, if any. Yes.
Obliged, Lordship.
16,
May I please, Your Lordship? My lord, in this case, what happened, petitioner was arrested and search was conducted under Arms Act, my lord, 25(1)A, my lord. And nothing was recovered from the possession of the petitioner, my lord. FIR says at 8:30 p.m., 8:22 p.m., search operation was, page 14, my lord. Search operation was conducted and, my lord, .22 pistol was recovered from the outside house of the petitioner, my lord. I have stated, my lord, because one of the seizure witness where I have a dispute with him, and for that, my lord, he has, my lord, engaged all these things. And he was behind bar, my lord, for since last 85 days. And section 47 notice was not served upon the petitioner, my lord. Section 47. 148 notice was served. Section 48 notice was served. BNS. Page 16. Where, my lord, no ground of arrest was communicated. Page 16, my lord. No recovery from the possession of the petitioner, my lord. Section 25(1)A says, my lord, recovery should be from the possession of the petitioner, accused, my lord. Here is a case where, my lord, as per FIR, my lord, it is stated that the .22 pistol was recovered from the, may I read, my lord, that during search, we have recovered one .22 pistol along with one empty magazine and 75 numbers of live ammunition of 22 caliber marked as KF, which was kept concealed outside the house and just behind the window of his personal room, adjusted at his house palace. And he's behind since 85 days, he is behind bar, my lord. And ground of arrest was never communicated with the petitioner. I have checked it in the, my lord, scan copy, as well as I have annexed one document, page 16. Page 16. My lord, relatives are informed about the, my lord, arrest, but no ground was communicated. No ground was there, man. Page 16. Investigation has completed, my lord, charge sheet file. So, my lord, I rely upon Baihan Kumar and my lord Prabir Purkasto.
My lord, as far as the materials are concerned, my lord, I have objection, my lord, because there are sufficient materials in the case, because searches has been submitted, my lord. But my lord, regarding grounds of arrest, my lord, I have also checked the my lord LCR, my lord. The 47 notice I have not found, my lord, whether it is served or not, I don't know.
48 is there.
48 is there.
48, no ground of arrest mentioned by there.
But as far as materials are concerned, my lord, there are sufficient materials.
Only materials, my lord, only material, lordship kindly see FIR, my lord. That is not recovered from my possession, and I, in paragraph, my lord, 6, I have stated that, my lordship kindly see paragraph 6, page 5, that the accused petitioner beg to state that the accused petitioner is innocent of the allegation made in the FIR, and he has never been indulged in any offence as stated in the. It is also stated that the accused petitioner is not owner of the seized article. He is nowhere connected with the allegation made in the FIR. The petitioner is a driver by profession and one Tahur Ali, son of so resident of Lahorijan Barbari, Katkoti, adjacent neighbor of the accused petitioner herein has dispute over the boundary with the petitioner, has threatened him to face the consequences if not agree upon him with boundary by sacrificing his area of land, and thereafter taking the advantage of absence of his wife at the house, push the articles inside the boundary of the house of the petitioner and managed to arrest him in connection with this so my lord. So there is nothing, my lord, in the record, my lord.
No, the record is there, but yes, it is your submission.
But section 47 is not served, my lord.
That is another
That part is
aspect.
different, my lord.
That part is different.
Both is-
Otherwise, that is your submission, you were out of grudge, you have been
Yes,
trapped. Anyway. Heard Mr.
JMH.
J.M.A. Chaudhary, the counsel for the petition, learned counsel for the petitioner. And also heard Mr. R.J. Burga, the learned additional PP appearing on behalf of state respondent. Scan copy of the case record, but this is an application only. Scan copy of the case record has already been received. It is submitted by Mr. Chaudhary, the learned counsel for the petitioner, that present accused petitioner is innocent. And nothing has been seized from the conscious position of the accused petitioner, though it is alleged that the arms were recovered from the house of the accused petitioner. Further, he submitted that the one of his neighbor tried to trap him in this case out of previous grudge. Without any fault of the present accused petition, he is languishing in jail hazard since last 85 days. Next para. Further, it is submitted by Mr. Chaudhary that the accused petitioner was never served it in notice under section 47 BNSS, and that apart, the notice which was issued to his family members under section 48 PNSS also does not disclose any ground of arrest, which is mandatorily required and is in total violation of the provision of Article 21/22 subsection 1 NDPS Act, subsection 1 Constitution of India. In that, and accordingly, he submitted that in that count also, the accused petitioner is entitled for bail. Mr. Chaudhary further relied on the two decisions. So, আমি চাই ল'ব এটা হৈছে বিহান কুমাৰ, এটা হৈছে পবিত্ৰ প্ৰকাশ। The order is there only, no? Next para. Mr. Burga, the learned additional PP, submitted in this regard that there are sufficient incriminating materials against the present accused petitioner, and on the basis of which the charge sheet has already been filed. But he submitted that he did not find the 47 BNSS notice in the case record, and hence is not in a position as to whether the notice under 47 was served on the accused petitioner. First of, however, he admitted that the section 48 BNSS notice does not disclose any grounds of arrest, which is available in the case record. However, he submitted that considering the nature and gravity of the offense, the bail prayer should not be considered at this stage. Baki hinam officer TS. We'll
Okay.
pass you all. All are rest and then what you can do, okay, very cut this good. This is a preliminary part to my details. Yes.
20,
Wait, please, your lordship. Lordship, this is an regular bail application, lordship. Today's statutory period is over, lordship. Intermediate quantity, lordship. He was arrested on 1-2 and forwarded on 2-2, lordship. Today's lordship 61 days, lordship.
Yes, any other submission?
Is entitled for default bail, lordship. Since charge sheet is not there, lordship, case diary is available here.
CD is just, whether
CD
charge sheet is there?
CD is there, lordship, but in today's, nowadays, lordship, CD is not necessary to file the charge sheet, lordship.
No,
So-
whatever, do you have any information?
I don't have the information, lordship,
What to say?
but it is 61 days. lordship.
Today's 61 days.
Intermediate quantity. I add two lordship, then lordship. I will ask them, through telephonic information, I will take telephonic.
In
information.
Kapil Vadani case, lordship, that 60 days will be counted if they have not filed within 16 days, 60 days, lordship. The petitioner is entitled for default bail, lordship.
No, we are not.
Not on the.
He is
before-
saying that
Is it?
sometimes nowadays it is happening that even without the case diary, by
lordship, charge sheet
opening a
are-
supplementary
That-
case diary,
that he
charge sheet
not-
may be filed. That's
that-
what he is.
That he could obtain it today because of
today,
phone,
No,
lordship.
today,
I am
today.
today.
He's going to obtain today. only.
Yes,
I will-
after some time, lordship.
Hmm.
It is, everything is there, lordship, but in the seizure list, one is that tablet, lordship. It is written here. It is written there 86 numbers of blue colored SPM PRX capsules and 21 so and so, lordship, having total weight of 80 gram, suspected to be containing contraband physiotropic substances, tramadol. If it is tramadol, lordship, then it is intermediate because
Yes,
it is 80 gram and there is written
80 grams and 250
80 grams, 250
It is
commercial.
the commercial quantity. Serial number.
Let him, he is submitting.
Lordship. So if I look into the CD, lordship, it should be intermediate. I don't know, lordship, why C has
It's a
been
mistake,
given.
your lordship, something mistake.
So tablets are, your weight is 80,
80, lordship.
Yes.
tramadol.
80 grams.
Serial number 238
As per
is
seizure list, lordship. Looking into the seizure list. And
Inventory,
ganja
there
is also
is-
647 gram. That is also,
That is too
that is
undoubtedly
small, lordship.
small quantity.
And moreover, heroin also
30.
33.84 gram and 105. That also 138. It is not above 250 gram.
Heard MSA Mehdi, the learned counsel for the petition. And also heard Mr. K.K. Das, the learned additional PP appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. CD received, parents the same, heard both sides. It is submitted by MS Mehdi that the accused petitioner is innocent and he is in custody since 3/11/2024 and today is 121 days. He is behind the bar. She further submitted that as per the FIR, it is alleged that 33.84 grams of heroin was suspected to be heroin was found in possession of the present accused petitioner on his body search, and 16 numbers of tramadol tablets have been recovered, which is around 80 grams, which will be around 80 grams as per the seizure list. Thus is submitted that further it is submitted that the quantity of the cannabis alleged to be found in possession of the accused petitioner is only 645 now.
647.
647 gram, which also comes under the small quantity. Accordingly, she submitted that considering his length of detention, the nature of offense, he may be released on bail. Full stop. Further, the accused petitioner being a local person will provide genuine security if he is granted with the privilege of bail. More so, the accused petitioner is still ready and willing to cooperate the IO in further investigation of this case. If further investigation of this case first. Next para, Mr. Das did an additional BP submitted in this regard that there are sufficient incriminating materials against the present accused petitioner and the contraband was alleged to have been recovered from the conscious possession of the accused petitioner. First. However, he submitted that considering the quantity of the contraband which was alleged to have been recovered, that is 33.84 grams of heroin and 16 numbers of tramadol tablet, which amounts to 80 grams and 647 grams of ganja will not come under the
Moreover, one
commercial quantity.
heroin is also there, 105. In the car lot,
Fire 105.
105. 105 gram. Total heroin will be 33.84 and 105 gram.
And out of the mother job and further recovery 105
105 gram.
105 gram from his vehicle. However, he fairly submitted that even if it is considered to be even if the recovery but recovery as per the seizure list would not cover the commercial quantity, though it is registered under the same.
FSL is also not different.
Hmm?
FSL is also not different.
Further, he submitted and FSL is not yet received and further and the investigation is still under process. Next para, considering the under submission made by London Council for the petitioner and the respondent without going full stop, without going further details of the merit of the case, considering the length of detention and the quantity of the contraband alleged to have been recovered from the possession of the accused petitioner, I find it a fit case to extend the privilege of bail to the present accused petitioner. To this extent, where it is pending?
It is pending at special judge under NDPS at Kamruk Metro.
No, 1, 2, 3, any?
No, it is not pending. It is not a chargeable matter, Your Lordship. It is pending under special judge under
This
NDPS
Kamruk
Kamruk Metro.
Pem.
Yes,
Okay, you are granted bail. You are granted with bail.
yes, Lordship. Obliged.
19.
May visit your lordship.
Yes.
Lordship, this is a charge sheeted case. Case is pending, lordship, before the honorable court, lordship. He was arrested in the month of August, lordship. So more than 7 months he was behind the bar. Allegation, lordship.
Prior to taking up, my lord, I have just informed by the legal aid office, my lord, that I have to appear for respondent informant number 2, my lord. So I may allow some time, let it be on Friday, my lord. In the meantime, I will go through the record, my lord. They have yet to submit me the papers, my lord. Just verbally they inform me.
Friday.
For legal. Respondent number 2, informant. Or otherwise, for my part of submission, let it be on Friday, but my.
No, listed, it will be listed on Friday itself. Your name is also not reflected, I think.
Just now they have informed me over phone that I have to appear.
Okay. And you are also from the legal aid council?
Yes.
As scan copies are available, my lord, lordship may produce, but for my part, it should be on Friday.
No, it will be on Friday.
Ma'am.
And a part will be. At a request made by the the learned legal aid counsel for the respondent number 2. Let the matter be listed Friday will be with
Court.
court. Realistic.
My name may be reflected.
Yes.
Okay.
Him. Further, registry is hereby directed to reflect the name of the learned legal aid counsel, Mr. M. Burman, on the next date listing. List accordingly Friday.
Twenty and 21.
May I please, your lordship?
2020.
May I
Yes.
please, my senior lordship, my senior friend lordship, A.K. Purkasta, he is in Arunachal lordship. The matter being regular bail lordship, so he have asked me to appear lordship. I may be allowed to move the case.
In both the matters.
About the matters. One more matter is there, suppose here, you have mentioned it to the morning. It is supposed to be listed around 2 o'clock, I think. Lordship,
Maybe.
sorry. When it will come, lordship will move it, lordship.
The other matter also you're going to move.
Lord. When it comes, lordship will move. Yeah, what happened, lordship, case diary was called for. This is the regular lordship, 39 days behind the bar lordship. What, huh? 46 days lordship. What happened in this case, one person was arrested by the police while he was carrying a kettle in his vehicle lordship, in a private vehicle. And thereafter he was arrested, and later on lordship, this person was arrested, which is of his statement lordship. And
The person who was initially arrested is not here before us.
no, lordship. No, and on his statement, basis of his statement, these two persons were arrested, but no seizure was there and nothing has been found against them, lordship. They are behind the bar, they were taken in custody.
One cattle was.
One kettle was recovered from that other person, lordship, at the time of arrest. He was carrying in his private vehicle. One kettle he was arrested, and thereafter his interrogation, our name might be revealed, and police have arrested us. But at the time of our arrest, nothing was recovered from us, lordship. In regard to item 20, we are taken in custody, also police custody, thoroughly interrogated, and nothing was revealed, and no seizure, no seizure from us, lordship, in regard to cattle. The main basic allegation is regarding theft of cattle and lordship transportation of cattle. This is the basic allegation of this FIR, lordship. And in regard to item 21, lordship, this person was arrested. His allegation is that he purchased one cattle from the main person who was arrested, lordship, in the initially, lordship. This is the case. It would Bishop Kiman religion. 57 petition. In regard to item 20, 45 days behind the bar, lordship. Petitioner number 1, lordship.
Item 20, 46 days.
45 days, lordship. There are two petitioner in item 20. Petitioner number is 45 days and next to him. And petitioner number 2 is 47 days behind the bar, lordship.
In item 20
Lordship.
and 21.
21. Huh? Item 21, 47 days. Further custodial detention might not be recovered because nothing has been recovered from their possession on the basis of the co-accused. They were arrested, lordship, custody taken. And further, lordship, one more ground is there, though it is 45 that regarding that 47, lordship, notice that has not been complied on because they already 45 days and 47 days, lordship, that I think will not arise now.
Yes, Purva. Otherwise, 47, 48 are also there.
Are not there, lordship. Not complied with, lordship, as per the judgment, lordship, behind judgment, it has been complied with.
Anyway, have you annexed this?
No, lordship, no.
Yeah.
Because now, lordship, I don't take that plea also, lordship, because already 45 days and 47 days now. Further custodial might not be required, lordship.
Yes, Purva.
But they are all my lord veteran cow lifter, my lord. Although my lord the cow recovered from stolen by one my lord Rasidul Ali, my lord. But my lord, in conspiracy, my lord, they all together they are involved, my lord. Now, my lord, as far as this Annarul Haq and another person is concerned, my lord, what you will kindly see, my lord, the accused number 2, Mofidul Ali, my lord.
In which item?
Item 20,
Item number 20, my lord, Mofidul Ali.
petitioner number 2.
He along with one my lord Nazbul, my lord. They
Hmm.
lifted the cow, my lord, lifted the cow from the village, my lord, village people, my lord. Then, my lord, they sold the cow, my lord, to one, my lord, Bulayat, my lord, petitioner number, my lord,
21.
item number 21, my lord. And from his position, my lord, one cow recovered. my lord.
He purchased it, Lordship.
He
From
purchased
from
it.
item number 21
21,
recovered.
my lord.
He's a purchaser, Lordship. He's
No,
a
recovery is
Part-
from item number 21.
When he is a purchaser, Lordship. It clearly says, Lordship, purchaser,
The
Lordship.
purchaser knowingly that it is a stolen one, my lord. Maybe a purchaser, my lord,
Lord.
but knowingly that it was a stolen cow, my lord, he purchased, my lord.
And for that, Lordship, already have got 47 days behind the bar.
So, my lord, as far as the materials are concerned, I have perused the case there, my lord, there are sufficient materials, my lord. And I have also objection, my lord, regarding grant of bail, my lord. And regarding 47 notice, my lord, I have seen, my lord, that definitely, my lord,
That were not
this, my
compliant,
lord,
Lordship, and
grant of bail is specifically not mentioned, my lord.
45 days and 47 days was enough, Lordship. for that one.
Pardon me, 20 লিখা more or less একে হবে অলপ difference আছে there is some differences বেলেগকে লিখা হয় item number 20 had Mr. S. Munir appearing on behalf of Mr. A.K. Purtasta, the learned counsel for the petitioner, and also had Mr. R.J. Borga, the learned additional PP appearing on behalf of state respondent number 1. This is an application under section so and so in connection with so and so. You can see how to do it. CD receipt, parent receipt, hardball set. It is submitted by Mr. Munir, the present counsel for the petitioner. That the petitioner number 1 is in custody since last 45 days and petitioner number 2 is in custody since last 47 days. Nothing has been recovered from the possession of these two petitioners. However, they got arrested in connection with this case only on the basis of a statement made by the co-accused person who was arrested as when he was carrying a cattle in his private vehicle. Actually, further submitted that both the petitioners are behind the bar for considerable period, and hence considering their length of detention, they may be released on bail. However, both the petitioners are still ready and willing to cooperate the IO in further investigation of this case if they are granted with the privilege of bail. Next paragraph. Mr. Borga, the learned additional PP submitted in this regard that these petitioners are the veteran cow lifter and the petitioner number 2 is stated to be he was involved in the stealing of the cattle along with some other co-accused persons, and there are sufficient incriminating materials so far collected by the IO against the present petitioners. Accordingly, he raised objection and submitted that it is not at all a fit case to grant bail to both the petitioners at this stage. Next paragraph. Considering the submissions of learned counsel for both sides and without going detail of the merit of the case, after hearing the submission made by the learned counsel for the petitioners as well as the respondent, I have also gone through the case record of, I have also gone through the case diary. However, without going detail of the merit of the case, considering the length of detention already undergone by the accused petitioners, I find that further custodial interrogation may not be necessary for the interest of the investigation. Accordingly, I find it proper to allow both the accused persons to go on bail. To the how to whose satisfaction this one, this
CGM not looking good.
CGM not looking for it. These are all the bar.
Not
And the 21 of Mr. Munir's submission likiba that he is not at all involved in the alleged offense. However, it is a fact that he is a genuine purchaser and purchase was cattle from one co-accused, and that apart he is not at all involved in the alleged offense. বাকীখিনি লিখিব, however, he is ready and willing to so and so লিখিব। And he is behind the bar হৈছে 47 days। তাতে মিলাই দিব সেইটো, খালি submission attach যে he is a purchaser of that। আৰু বৰুৱাৰ, Mr. বৰুৱাৰ submissionত দিব,
Stolen cow recovered my lord.
they submitted that the stolen cow was recovered from the vehicle of the present accused petitioner. And it is suspected that he purchased the cow knowingly that it was a stolen cow, stolen cattle। Accordingly, Baki submission was still under process and then rejection of prayer. Baki kin process same, both etonoko didibo without going detail of the merit of the case for dibo to the satisfaction of CGM Lakhimpur.
Lordship, CGM Lakhimpur,
Not
not Lakhimpur.
CGM Lakhimpur, not Lakhimpur। Okay, you are.
Lordship, one is, prayer was there, Lordship, actually, Lanet PP to keep the case there here, Lordship, because one more case is coming, Lordship.
Today,
এটা আৰু understood আহি আছে, এইটো কেছ এটা কেছ এখন থৈ দিব না।
No, my lord, in that case, my lord, whether my lord, without calling for the case diary, my lord, that is the coming in a motion column. my lord.
can be, if it is available.
Case there is here, Lordship. Oh, Lord. Much obliged, your Lordship, much obliged, much obliged.
Pending 7th.
I'm sorry, my lord, I was in other court, my lord.
It's okay.
Sorry, my lord. My lord, the petitioner is an ex-MLA, and he was falsely indicted in the other two cases also, my lord. He got bail in those cases also, my lord. So his political rivals are trying to put him behind the bar, already could not. Now, this is a case, page 11 is the FIR, page 11. Here is a case, my lord, the petitioner demanded rupees 1 lakh per month from the informants. This is the case, my lord.
Demanded 1 lakh.
Demanded 1 lakh per month for business purpose. That is how FIR says, man. I admit, yes, but because I had he has borrowed rupees 1 lakh from me. 2 times I have telephoned him, my lord. And then when the last time when he refused, then I told him that I will have to no other option but to take the legal course action, my lord. Then this FIR was brought, my lord. So only, my lord, that way nothing happened. Otherwise, on the telephonic call, and I also say that I admit that yes, I telephoned him only to get my money, 1 lakh rupees he has borrowed from me, my lord, that he did not pay within the stipulated time. So I asked for money and subsequently he just took it as demand and ultimately he filed the case. So that way, my lord, I think, my lord, he is also in other two cases also, he is not named in the FIR, but even then, my lord, police was after him. We came before the court, this one court was pleased to grant him bail, my lord. Clearest bail, my lord.
Whom? This petition.
This petitioner. Earlier, so, again, he is political man, my lord, because he belongs to a political party, other side belongs to other political party. That's why, my lord, he has been implicated in the case, my lord.
Dear Lordship, in that statement, the person has stated that when they were driving their vehicle, Lordship, the present petitioner has stopped at the vehicle and they have having with pistol came from the vehicle and threatened so and forcefully demanded 1 lakh rupees per month. Otherwise, he would kill us and our families.
Now, you're looking at the FIR, my lord. What is the
Other
person
three
FIR?
persons are there also. 180
Showing pistol, they demanded money.
Lordship.
So the present petitioner also there.
No, can you FIR, my lord? FIR. FIR from pistol counts. Very improved version, my lord, certainly. Only telephonic call, my lord, in the FIR.
Few pages before also, like.
Three witnesses.
You are appearing for?
We have filed our wakala number. For the informant, Lordship.
For, you need some time or what? You are going to submit?
Mr. Biswas is appearing in this case, Lordship. He's out of station, today. He's out of. We have submission to make, Lordship.
You have received the case diary, no? It's very difficult on a prior view, we don't have any date in fact.
You also can is FIR matter. That's what matter I am saying. Nothing about pistol, nothing has come by.
Yes, I have said.
Only 2 telephone call. That is FIR says. In that case, if they need time, you kindly protection matter, interim protection matter, the responsible person matter, you also may file their objection. I hope my learned for him because Bihu is here, madam, because Bihu is not possible.
But they have already appeared.
And just, but they are to
Yes,
assist the PP, my lord.
We don't have any date in fact.
In that case, your lordship kindly matter if your lordship. I understand matter there is a problem before Bihu, but he is in travels matter. The other case he got bail in second bail, he is not in a position to appear, right?
The otherwise he is insisting for interim bail. In that
Yes.
case, do you want to have something to say?
But PP my lord, that to assist PP my lord, your lordship.
The crime committed is very grievous in nature, Lordship.
Huh?
The crime committed is very grievous in nature, Lordship. That's why we need some time, Lordship. Interim protection. we need
I
time.
will look for vote as a on 4th or looking vote as a
Interim Bihu, every day, lamba date.
not possible.
Huh?
The question is that 11, they are going to pick
From the
30,
meeting,
35
following
voters.
the-
It's from all the information received from the range. They're going to use minimum 35 numbers on 11. So you don't want to give it any matters on 30. 11. It will create another problem. That is space. Always from us.
from the informant area.
More than 50. More than 50. In that habitat. Your senior can come on next Friday somehow because we don't have all the matters we have fixed. This corridor Friday, this on Friday. Court. Okay,
On
next 4th.
fourth.
City written. City be written. City be written.
Standing for
May I please, your lordship? This is offenses under section 21B, hello? And I am behind the bar for since 16 February 2025. And my lord, the recovery was that 11.89 gram heroin, suspected heroin, so it's intermediate quantity. So rigors of section 37 will not come, but this is motion matter today. So short, it's a Panbajar PS case only. Short date may be given.
So you are behind the bus since when? 11.
February.
So how many days today?
More than 45 days. My lord, on law point, I want to submit, the maximum punishment in section 21B is up to 10 years. So if you follow one judgment,
No, we are considering 60 days only.
60 days. So that is, so on that basis, my lord, and my lord, in this case, I have annexed sufficient documents. What happened, my wife is pregnant of 3 months and I have annexed the medical documents, kindly come to page 22.
And in my absence, she was staying with my mother-in-law, and mother-in-law subsequently died on 17th of March. So she was alone in my house, rented house, and I have one minor daughter also, and she is also in it. So considering all these aspects, my lord, and I am the collecting waste.
After Bihu will cover, I think it'll be statutory period will be over. After Bihu.
It will be
He is in custody since 14.
47 days. And my lord, I have annexed the documents.
Any other submission from your side?
My submission, Lordship, that in his conscious position, yes, it is intermediate, Lordship, though it is in his conscious position, it is found, Lordship. And moreover, Lordship, CD, I call for CD, Lordship.
And we don't have
Yes, my
any.
lord.
Lordship.
Date we
Background,
don't
come,
have.
Lordship.
Background.
It will not come. Oh, you, there is no date, I understand that, Lordship, but in my
That I will appear before the IU for next every 15 days.
Otherwise, we have to consider the length of detention.
my objection may be recorded on the come, Lordship.
You are Mr. PK.
PK Sharma.
Heard Mr. PK Sharma, the learned counsel for the petitioner. Yeah, आपने last video with heard Mr. PK Sharma, the learned counsel for the petitioner. And also heard Mr. PK Das, the learned additional PP appearing on behalf of state respondent number 2, respondent. This is an application under section so and so in connection with so and so. Next para, it is submitted by Mr. Sharma, the learned counsel for the petitioner, that the accused petitioner is behind the bar since last
16th of February.
16/2/2025. 25 and thus the IO got sufficient time for his custodial interrogation. Further, he submitted that the case is of intermediate quantity and hence the rigor of section 37 will also not attract in this case. Mr. Sharma further submitted that his wife is also pregnant and in advanced stage of pregnancy, and there is none to look after his wife in his absence. And considering this ground also, his petition may be considered. However, he is still ready and willing to cooperate the IO in further investigation of this case if he is granted with the privilege of bail. Next one, Mr. Das, the learned additional PP submitted in this regard that from the FI itself, it is seen that there is conscious position of the contraband was recovered from the conscious position of the accused petitioner, and the case is still under investigation. Accordingly, he raised objection and submitted that and insisted to call for the case diary. Next para. Hearing this submission made by learned counsel for both sides, without going to the detail of the merit of the case, only considering the length of detention, I find that the IO got sufficient opportunity for custodial interrogation of the accused petitioner. And considering this aspect of the matter, I find it, this court is of opinion that the petitioner can be granted with the privilege of bail. And accordingly, it is provided. To whose satisfaction?
CGM.
And with CGM. Or before special judge is there. Where is the forwarding? We have annexed the forwarding here.
Wording, my lord. Page 14, 12, 14.
14.
CGM.
CGM was arrested before CGM. Actually, CGM corridor. Before CGM, to the satisfaction of CGM, Kamrup
Kamrup Metro.
Guwahati. Okay.
Oblige.
I find it difficult to grant bail to the present purpose petitioner. Where it is pending,
Today, satisfaction of my lord, session judge, learned session judge Kamrup Metro.
special just come up metro.
I think in item 4 also that needs correction.
Item
Yes,
4, you
the-
took the dictation.
CZ, to the satisfaction of CGM, because fast forwarding happens to be.
Item 4, you took the dictation. Item 4 also special just come up. Here also special just come up. That's why I was asking you, it's a special judge which
That
ought to
is-
be disposed of. Thank you.
I'm obliged.
23.
Please, my lord.
Hmm.
I was arrested on the 3rd February 2025. Now I've been languishing it as the last 59 days. The quantity is 2 kg, 836 grams. It's an intermediate quantity. It's a ganja.
Yes, does anything here?
Anything, lordship, in this case, lordship 59, he has stated the lordship, but we have
Yes.
not received FSL. And regarding the charge sheet, I have no information, lordship. I don't get time to ask lordship that.
So 59 is if it's there,
Yeah,
FSL is not available, the
Lordship.
probability of
Lordship,
filing charge sheet within 2,
Lordship,
3 days
lordship.
is not there, I think.
lordship.
Well, even others on default, it may be granted. Even others in on default grant, bail may be granted.
You are not accrued the right of default bill to is 59 days only. You are not accruing the right of default bill.
But considering the period.
Only
52
length
days
of
some-
detention may be considered, otherwise default bail is not there. Question of. Heard Mr. S.K. Deori, the learned counsel for the petition. And also heard Mr. K.K. Das, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. CD receipt, where is the same, heard both side. It is submitted by Mr. Deori, the learned counsel for the petition. That since when he is in custody?
Since 3rd of February.
Since 3/2/2025, the petitioner is in custody. And today he and custody, and thus he has completed 59 days in custody. But till that the IO could not find their charge sheet. Post of order, he submitted that the quantity of the alleged recovery was 2 kg, 836 grams of cannabis, which is also an intermediate quantity, and hence the rigor of section 37 will also not attract in this case. However, he is ready and willing to cooperate the IO in further investigation of this case if he is granted with the privilege of bail. Next paragraph. Mr.
Judge Metro.
Mr. Das, the learned edition PP submitted in this regard that there are sufficient implementing materials against the present accused petitioner. Full stop. However, the IO could not collect the FSL till date and thus there may not be any probability for filing charge sheet within 2-3 days. Next paragraph. Considering the submission made by learned counsel for both sides, without going into the merit of the case, only considering the period of detention that is on 59 days, I find that the investigating authority got ample opportunity to interrogate the accused petitioner, keeping him in custody. In view of this, the present accused petitioner is granted with bail with satisfaction where
Special Judge Guwahati Metro.
Kamrup Metro.
Kamrup.
Special just Kamrup Metro. Okay, it is disposed of.
Earlier batch.
24.
Yes,
It is not available.
under 48 days
It is
in
not.
custody, my lord.
CD not received.
48 days in custody, 60 days is a mandatory period, my lord. This is in custody since, my lord, 13 to 2025, my lord. Kindly considering.
1-3.
Yes, my lord. Allegation already, but 8 of POXO Act, my lord.
Oh, it's a POXO.
Yes, my lord.
Oh,
8 of
then.
POXO. Notice already, steps already taken, my lord.
This is what about notice?
The disciplinary check.
Take instruction.
Kindly considering the length of details.
No, it is a POXO, no? That's why.
Popso, my lord, you know, can you go to the affair, my lord?
No,
Kindly,
it's
my lord.
okay. I know, maybe may not be any matter,
lord,
but the
uh,
question is the age POXO is a,
Victim is a boy,
is
my
there
lord, 14
any,
years.
anything? No, boy is also considered to
Ah,
be a
Yes, my lord.
victim.
Only allegation of touching
Maybe boy.
the private parts. This is the allegation, my lord. 48 days in custody, my lord, is longer period in jail, my lord. He is a married man having wife, children, my lord. And there are some rivalries, my lord, previous, my lord. And due to that, my lord, this affair has been lost, my lord. I have already mentioned in my petition, my lord.
I'm sending question.
Yes, registered
That's
post-
what to do. Service is evited as per this officer.
So is there, lordship, there. Is there, lordship.
That's what.
It is deemed to be served, my lord, because registered post has been taken, my lord.
Have you given, one is any track consignment report?
Consignment report, I have not, my lord,
Then?
taken, my lord. It is officially
It
served, my
was
lord.
reserved to register post. How?
Yes, my lord.
How? Why?
Registered to show, my lord, register office, my lord.
Why?
High Court, my lord. I have submitted, my lord.
No, why? Because there is a process now. It cannot be registered post.
Registered
How it was
follow-
gone through registered post?
Registered as well as usual post, my lord.
No, how? It
Talabana,
cannot
my
go
lord.
That is, my lord.
through registered post. How it can go?
Postal Talabana, my lord. Postal Talabana. That is kind of registered post, my lord. From
It has
postal-
not gone through your office.
So,
Postal Talabana.
But you have received this one.
lordship,
PP office has received.
Yes, ma'am.
but we have not received anything, lordship. Office has not given us anything, lordship.
No, it is received by you.
Yes, my lord.
Here, it is received by you.
48 days in custody, my lord, kindly, my lord. Considering the length of detention. my lord.
Side দেখার দিন
Is it-
আমি দেখা দিল side.
I need to look into it.
On punishment 5 years, my lord. Minimum 3 years.
So, APP it is written, my lordship.
Hmm.
Service report is awaited, lordship, expected here. So, APP, lordship, not my.
True. APP means
Information, lordship. We need to take information, but
otherwise he is submitting that he is behind the bar for 48 days.
60 days is a mandatory period. Only 12 days left.
the service report has to be given through OC, lordship, to us.
Don't know how it has gone.
Yes, my lord.
You took steps.
Sir,
No, through registered post.
Postal Talabana.
Who asked you
submitted.
to take steps to
Postal
register?
Talabana, my lord. I have already received the copy, my lord.
Postal Talabana कुने दिए हैं?
Take it to the registry.
Through registry. It was
Registry, my lord.
Why it was not, order was not in that manner. No, I don't know. You have received or someone other in your office. I don't know.
Lordship. The steps has been received and notice issued to respect so APP, lordship. It is the usual process that the notice sent through the registry to us, lordship, and we send it to the
Yes, concerned police. station.
concerned police
Yes.
station. It may be that, lordship, our office has been given the notice to the OC, lordship. But till now, OC has not given us anything, Lordship.
My lord, kindly, my lord, 48 days in custody, my lord.
Yes, any other submission from your side? Where is the FIR?
FIR, my lord, case 15, my lord, main vernacular, my lord.
10.
Yes, my lord, 15,
10.
my lord.
Huh?
10 is the, my lord,
Right.
translated copy, my lord. And main vernacular 15, my lord. Assamese version, my lord. 14 years boy, my lord. Allegation or touching, my lord. This is, my lord. There are some previous rivalries, my lord, from the that, my lord, this affair has been lost, my lord. I have already been at para 4, my lord, of my petition.
Mr.
If you look into the Lordship, the forwarding is also there.
Yes.
It is that it is mentioned that the arrested victim is a minor of 14 years and accused was following him in night while victim was returning from a relative house, and in a lonely place, he caught him and touched his private part.
My lord, there was a marriage ceremony, my lord.
If you
all
go
are
by
coming.
the forwarding, Lordship.
There was a marriage ceremony, my lord, nearest, my lord, village, my lord. All are coming, my lord.
Heard Mr. T. Hussain, legal and counsel for the petition. And also heard Mr. K. Das, the learned additional PP, appearing on behalf of state respondent. Otherwise, you have received the case diary? No. CD was not called for, I think, nah.
It will be called for.
No, CD was
It
called
was
for.
called for on 21/3.
You have not received the case diary. They did not proceed. And from the office note dated 28/3/2025, it is also seen that services still awaited for the response number 2. However, Mr. Hussain submitted in this regard that the accused petitioner is behind the bus since last 48
days, my lord.
48 days. And hence there is a sufficient opportunity for the IO to investigate him in custody. However, the petitioner is still ready and willing to cooperate the IO in further investigation of this case, if he is granted with the privilege of bail. Next, Mr. Das, the learned PP submitted to this regard that from the FIR itself, it is seen that there is allegation FIR as well as from the forwarding report. It is seen that there is an allegation of sexual assault on a 14-year-old minor child, minor boy, male child, minor boy really hello.
Robert threatening party is also there. Lordship.
When he was in a lonely place and also threatened not to disclose the thing to other persons. Accordingly,
Lordship,
Mr.
withdraw the case.
Huh?
It is there in the FIR. Accused threatened complainant to withdraw the case.
Oh, acha. Further, he submitted that as per the forwarding report, he also threatened the informant to withdraw the case. Accordingly, Mr. Das raised objection and submitted that it is not a fit case to grant bail to represent accused party at this stage. Next para. After hearing the submission made by learned counsel for both sides, without going into the detail of the merit of the case, I find that the IO got sufficient opportunity to interrogate the accused petitioner as he is in custody since last 48 days.
13/2/2025. 48 days.
Considering the length of detention. Today, where it is pending?
It is not for Jorhat, my lord. Special judge
Special
for
judge
Jorhat.
also there.
Deputy level, my lord.
25.
May I please your lordship, my lord?
Yes.
My lord, in this matter, CD was called for and I am told that CD is not here. And if your lordship permits me, my lord, I'll just make 2 submissions, my lord. My lord, first submission is that if your lordship kindly turn to page number 47. My lord, this was the notice which was given to me. And admittedly, my lord, this notice does not contain any grounds of arrest, my lord, even under section 47 and 48 of the BNSS. Now considering
No,
the
this
fact,
is 48, 47. Where is the 47?
my lord, the 47 notice was not given at all, my lord. It was not given at all. So now considering the fact that even the grounds of arrest has not been reflected, my lord, in this notice in 48 BNSS, my lord. So lordships may kindly take note of that, my lord, Vihan's judgment, my lord, and then
It's okay, but we don't have any, this, it is still under investigation, I think.
it is still under investigation. But even if it is
without
still under
anything-
investigation at the time of, my lord, arrest, so the doctor, my lord, the dicta is that, my lord, at the time of arrest, I should.
No,
see-
we are,
Yes,
yeah, definitely.
Yes, madam.
This is 48, you have
yes,
annexed.
sir.
This
And
is
my
for the
lord,
family
my lord,
members.
if
No,
I
I'm
may-
saying that we are not in a position to say anything whether 47 was issued or not,
Yes,
without
sir, because
resolving
the
the case
city is
diary.
not
That
open. I
is,
understand that.
that is.
Now,
the
my lord, my
obligation.
prayer before you lordship will be, my lord, let the matter come upon 9th, my lord. Because unnecessarily I am behind the bars today. It is around 36 settlement. It's 35 days, my lord, for an offense. If your lordship kindly peruse the FIR, my lord, I am neither named in the FIR, not nothing, my lord. The FIR relates to some transaction between two people. I am a person who is not at all connected, my lord. And my lord, I am taken into custody since the last
Can it
35
be
days. I am
possible,
behind bars,
Mr.
my lord.
Das?
From Tejpur, my lord.
Issue reminder, otherwise.
From
we have not
Tejpur, my
received.
lord. I will try,
From
my lord.
Tejpur,
From Tejpur, my lord.
10 Pari, 9 Pari.
Let it be on 9th, my lord.
Rushing with the case record. I don't know how it will be possible. Huh? We'll try on 9. Let it be.
On 9th,
Issue reminder, 9:42. Okay.
my lord. I am diplomatic.
26 to 31.
Like, yeah, was true.
Let's say 26, 27, 28, 3 I am here.
26,
So you-
27,
3, but 26, 27, 28. So there is,
26, 27, 28.
Okay.
You are absolutely.
so interim order was granted, interim bail order was granted on 6, 3/25. 27 from 27. 27, 28, 29. My
Not
case.
26.
No, sorry. So interim was granted on 6/3. So thereafter it is extended on 2/4. So this case is arising out of the common FIR. Why my case? Because first case, 417.
গোটেইকেইটা এবি আছে তো, B to 50.
Bail application is item 26.
Huh? No. Oh, acha, address is address AB.
And 31. 26 and 31 are clear. 27, 28, 29, 30.
These 4 are AB.
Yes.
Yes, oh, so earlier you were on interim, in 2 occasion CD fix, it has not.
No, CD was examined.
CD was called.
CD was called for, CD was examined.
CD
That-
was examined.
Yes, Lord. In the order it is there.
Also. This is 24.
6/3/25 order is there.
CD get examined.
Order.
CD was examined.
Exam, yes, this is the order.
Then why it is not available here?
27. Item 27, 28.
It's an item 29.
Which was the total for that?
Right.
16.
6th.
এটা 48 line. Where from we are saying it is CD was there. Item number 20.
Paragraph 4 is
No,
the
in
order.
other matters you are not on interim,
No.
only on 29.
No, I'm 27, 28, 29.
No. Only in item number 29 only you were granted with the interim.
Oh.
Only item 29.
No, 3 matters connected together.
Oh, ekkal lage.
Link.
Linked order.
So as per order of 6-3, you are on interim.
Yes. Connected 3 matters.
417, 418, 419. AB.
Yes. In those matters, they were granted with interim. And then, yes, what are the submission?
A submission is that 417 first matter is a person's disability. Kindly lordship turn to their disability certificate. Annexure
417.
417. Annexure 2, page 12. This is the certificate. So such type of locomotive disorder, whether he can attack the police, that is my question. Certificate is there,
The AB
page
47.
12. I have annexed the certificate.
You have annexed the order, page number?
Page 12. Certificate issued by the medical department. This is the case of multiple disability. It extend a permanent physical disability. If that type of person can, whether it is believable that he can attack the police, he cannot come out independently from the house.
Okay, now item number, as per you, item number 27, he has some he has the locomotory disability. So disability certificate was
Yes.
issued in that regard. And what about others?
The other 418, he is a Gaura. So it is a government Gaura. The incident took place in front of his house and he came out to pacify the people. It is his duty because it is a Gaura. He came out from his house to control this situation because it is his duty because as a Gaura, he is a responsible person. So he is also dragged in this case. The government Gaura, so a certificate is annexed here. That page 12 is a certificate, the Gaura certificate. The incident took place in front of his house. That is the only allegation because his duty is as a senior citizen, as a Gaura, to pacify the people. He came out from his house. That is, he has dragged out in this incident. What is his fault?
Yes, then
Then third one, he is a heart patient. Heart of bypass operation was page 12 is a certificate. Recently, his operation took place, bypass surgery. He was also dragged. He was inside his house. In the FIR, all names are listed in the village.
but these are all FIR name records.
In the name FIR. In the FIR, it is total, I think, total name includes. That is why I'm for these three only I filed this petition. One is that the heart patient, then locomotive disorder, and is a Gaura. That's why after seeing the case diary and also court has agreed to grant the interim order. So my prayer is to be made absolutely because they are already give their statement inside the court as per direction of the court. They appeared before the police station. So this is my submission.
In that regard, I want to state your lordship, in the witnesses, the police personnel, they have clearly stated that this person, the Mazhar Ali, who is the Gaugura, he led lordship. And among the other persons, they are the relatives. Some of them are also relatives lordship. and the villagers, there was about 200 to 300%. They surrounded the police vehicles, Lordship, and the allegations.
Why?
Allegations are serious because one Johar Ali and another is Salim. They were the persons, they are in another case for interrogation. They were took these persons to police station for interrogation. Then these persons held these two persons to escape, Lordship.
Johar Ali and one?
One Johar Ali and another is Lordship. Salim, Lordship. Saiful Islam. Johar Ali and Saiful Islam. They escaped, Lordship. Then again, police had to apprehend them, Lordship. Allegations are serious. They help and deter public servant, Lordship, to do their duty. Moreover, grievous injury is also stated that in the FIR, but I have not found it in the CD, Lordship.
So medical is there or not?
I have not found.
No, otherwise simple or whatever, medical report is available.
No, I have not found. I don't know why, Lordship. Moreover, they have appeared, these persons, those were on interim, but I have not found the statement of one Moinul Haq. He may be appeared, but I have not found in the record. XCD. Other person, Mazhar Ali and Mebzal Haq. Statements are there.
So as per things, the Mazhar Ali took the lead,
Took the lead,
being a Gaumbara.
bring Gaura. That is the main allegation, Lordship. And he instigate, Lordship. And moreover, the purpose is to escape two person, Lordship, who were in the FIR also it is stated here, who were in different. In another case, who were involved in Tula PS case number 175/24 under section 61(2)/3192/304. Oh, sorry, Lordship, 308 within bracket 4 BNS.
Tula PS case number 175.
175/24. This Saiful Islam and Johar Ali were there in the police vehicle. And in their statement also, they have stated that some persons shall help them to escape them. So they have not name, Lordship. And there are also FIR name, Lordship. And no malice is there, Lordship, in the part of the police, Lordship. Why they will implicate a Gaubra, Lordship.
Yes. Order করে দিবেন কমন অর্ডার করে দিবেন কেন তিনটা ABS আর দুটা BS. Yes, two BAs are there. I have seen. তিনটা AB আগতে করিলাম তিনটা AB item 27, 28, 29. একটা করে দিব পারো নি কমন কি করি কই দেয়া ভালো No, 27, 28, 29 to একেলগে করে দিবি সেপারেট একেলগে করে দিব ফাইন Mr. H. Rahman, the learned counsel for the petition. Senior senior advocate, Mr. H. Rahman, assisted by
Vijay Das.
BJ Das, the counsel for the petitions. And also heard Mr. KK Das, the learned additional PP, appearing on behalf of state respondent, so and so. This is an application under section so and so in connection with so and so. You have not received, you have not find the statement of which one? Mazhar Ali.
Moinul Haq,
Statement is not available.
not available. But I don't know, Lordship, here stated that This statement is there, may I read Lordship? But why the statement is not, I have no idea on that.
That is a visible person.
But he has not appeared.
I don't know if he has appeared.
Pardon?
He has appeared. Both, all the three persons appeared as per direction of the honorable court. Recorded the statement.
Anyways. So what to do? He's not appearing?
In the CD, Lordship, 3 persons names are there, all the 3 persons. Lordship, the statement of the accused are recorded on a separate sheet and enclosed with the CD. But I
We are
have
not
found,
finding.
but I have found these 2 statements, Lordship.
Okay,
One
okay, we'll make it
Mazdur
up.
and Maja. I have not found these persons.
Monul is not there.
Not.
But as per the
So and so,
statement,
estate by
recorded.
so and so, city
Ordered.
receipt, written the same, at both side. Poster. It is submitted by Mr. Rahman, the learned senior advocate, that all the 3 accused petitioners, namely Moinul Haq, Majar Ali, and Mabjal Haq, had already appeared before the IO and cooperated in the investigation of this case. After obtaining the order of interim pre-arrest bail dated 6/2025 at 25. Poster. For next paragraph, further he submitted that the accused petitioner in AB number 417 of 2025, Moinul Haq, is a physically handicapped person and he is already the certificate of disablement is already issued in his favor by the authority concerned, wherein it is described that he has the locomotory disorder. He at the relevant full stop, at the relevant time of incident, he was inside his house, but as is a resident near to the place of occurrence, his name was incorporated in the FIR. However, he is still ready and willing to cooperate the IO in further investigation of this case if he is granted with the privilege of pre-arrest bail. Poster. Next paragraph. In connection with the AB number 418 of 2025, it is submitted by Mr. Rahman that the petitioner Majar Ali is a government Gaumbuda and he arrived at the place of incident only to control the situation. And as the incident took place in his front of his house, and being the Gaumbuda, he was only tried to pacify the persons gathered in the place of occurrence. That apart, most of that apart, he has no, he is not involved in the alleged offense. However, he is ready and willing to. He has already cooperated to agode likhisen and alage likhibo pare. Next paragraph. Mr. Rahman further submitted that the petitioner Mabjal Haq
He's a heart patient.
in connection with AB 419 of 2025 is a heart patient.
His
And
operation
he
was
was
done. Heart operation was done.
and his operation was when it was done.
It was the operation was the medical certificate.
And he also got operated and he also undergone the heart surgery.
21/1/25.
Heart surgery on 21 to
1/25.
2025, and he was on rest at the relevant time of incident. Post op, however, his name is also incorporated in the FIR only as he is also a nearby resident of the place of occurrence. All the 3 petitioners have already extended their cooperation and are still ready to cooperate in the investigation and hence and ready to cooperate in investigation if they are granted with the privilege of pre-arrest bail. Post. Next paragraph. Mr. Das still on additional PP submitted in this regard that though as per the case diary, the all the three petitioners were appeared before the IO after obtaining the order of interim pre-arrest bail on 6/3/2025. However, the statement of accused petitioner Moinul Haq is not available in the case record, the case diary. Further, he submitted that all three accused petitioners are the FIR named accused and FIR named accused, and they took part in the alleged offense. Mr. Das further submitted that accused petitioner Mazhar Ali, who is stated to be the government Gauvara, took the lead of the case, and he instigated all the villagers and helped in escaping two criminals, which were already in police van. Those two accused persons were on the police van to help in escaping two accused of criminal, two accused persons, namely Johar Ali and Saiful Islam, who were apprehended in connection with Thula PS case number 175/2024 and was available in the police vehicle when the around how many persons? 2,000. 200 to 300 people gathered in the place of occurrence, and they helped in escaping, say, Johar Ali and Saiful Ali with the instigation of the present petitioner, Mazhar Ali. Accordingly, he raised vehement objection, and in granting a privilege of pre-arrest bail to the petitioners, especially the accused petitioner Mazhar Ali, who is the main instigator of the entire offense. Stop. Next para. Considering the entire submission made by learned counsel for both sides, materials available in the case diary, and other aspects of the case, I find it proper to extend the privilege of pre-arrest bail to the accused petitioner, namely Moinul Haq and Mabjal Haq, who already extended their cooperation in the investigation also, and other materials available in the case diary to milai diba. And accordingly, the order of interim pre-arrest bail dated 6/3/2025 is hereby made absolute, in which who were granted with privilege of pre-arrest bail in connection with AB 417/2025 and 419/2025. However, considering the materials available in the case record, I do not find it justified to extend the privilege of pre-arrest bail to the petitioner Mazhar Ali in connection with AB 418/2025 and his custodial, and it is fine that his custodial interrogation may be required for the interest of the investigation. Accordingly, his petition prayer for pre-arrest bail is hereby rejected, and the order of interim pre-arrest bail dated 6/3/2025 is hereby stands vacated. Your two petitioners, that is Moinul Haq and Mabjal Haq, is allowed. Petitions are allowed. Their order of interim bail 6/3/2025 is hereby made absolute. And in connection with Mazhar Ali, who is stated to be Gauvara, his prayer is rejected.
That's why it comes, he has property already, they appeared before the.
Yes, his prayer is rejected. Yes, 27, who is appearing? Sorry, 26, you are appearing.
26, my submission is that as I am already arrested here.
Since when you are in
That's
custody?
37 days behind the bar, my lord. So only submission at this stage, my lord, as my statement has been recorded, my lord.
See,
So
he is
two,
Jawahar Ali.
two petitioners.
The
three
person who were
petitioners,
inside the vehicle.
Johar Ali,
Then later on
Masab
they get
Ali,
arrested.
Saiful Islam.
They got arrested.
Again,
Now-
later on.
Now, question is that obviously escaping from a police vehicle is very heavy offense.
Yes,
But
ma'am.
the question is they are already arrested in connection with Dhula,
No, my lord.
175.
Dhula, my lord, they got anticipatory bail. For Dhula PS, they were brought, my lord. For Dhula PS, my lord, they were brought. So some people gathered, something happened there and they went away from there, my lord. And they filed a bail application for Dhula PS, the original case, my lord, for which in Dhula PS, my lord, they case, kindly see, my lord, page 14.
Page 14.
Page 14. Dhula case, my lord, there is no reason to escape, my lord, because they got anticipatory bail. Kindly see page 14, my lord. Oh. 14, my lord, page 14.
There they were granted with pre-arrest bail.
Pre-arrest bail, my lord, Dhula.
Was it an interim or pre-arrest?
This was an arrest, my lord. Now 37 days.
No. 5/2/2025, where pre-arrest bail was granted. Final order.
Final
Not
order.
interim.
Not interim, final order. So in this case, my lord, my only submission is that, my lord, 37 days behind the bar, my lord. They will, their statement has been recorded and they will cooperate with the investigation. Any stringent condition may be imposed on them, my lord, considering the period of detention, my lord, at this stage.
So you have filed this petition only for which one?
It's 3 persons, my lord.
One
Johar
Johar
Ali,
Ali.
Masab Ali and Saiful Islam, my lord. 3 persons.
Johar Ali and Saiful are the accused of the Dhula.
Dhula, my lord.
And one
Mas-
other one,
Masab Ali, my lord.
Masab Ali.
Masab Ali.
Yes, sure, does.
It may be lordship, as they were in the vehicle lordship, and for them, this person's attack lordship. So materials are definitely their lordship. Otherwise, I leave it to lordship with the custody integration on that part.
Only when a custodial period that will be considered, my lord. Nothing else, my lord.
Otherwise, material is there. Because of, for them, this person attack lordship.
AB would have been different, my lord. AB would have been difficult. This is BA, my lord. That's only consider, my lord, that custodial declaration, my lord. Only submission is that any stringent condition, my lord.
Heard Mr. D. Sharma, the learned counsel for the petition, and also heard Mr. K. Das, the learned additional PP appearing on behalf of state respondent. It is respondent, full stop, CD receipt for review. It is submitted by Mr. Sharma that the present 3 petitions are behind the bar since last 37 days. And thus the IO got sufficient time for their custodial interrogation. Further, the accused petitioner Johar Ali and Saiful Islam are no way related in the alleged offense, as they already granted with the privilege of pre-arrest bail under Dhula PS case number 175/2024, wide order dated 15/2/2025, passed in Miss B case number 77/2025 by the learned session judge Dorong Mongoldo. Further, they are behind the bar since last 37 days, and thus the IO got sufficient opportunity for their custodial interrogation and custodial interrogation. However, they are still ready and willing to cooperate in the investigation of this case if they are granted with the privilege of bail. Next para, Mr. Das, the learned additional PP submitted in this regard that the petitioner, accused petitioner Johar Ali and Saiful Ali are the persons for which the entire incident had happened, and they were helped by the other petitioners to escape from the scene, and thus there are sufficient materials so far collected by the IO during investigation along with the other accused petitioners. Accordingly, Mr. Das raised objection and submitted that further custodial interrogation may be required for the purpose of investigation. Next para, considering the submission made by learned counsel, and materials available in the case diary. This court is of opinion that further custodial interrogation may not be necessary for the interest of the investigation. To the satisfaction of which court?
CGM Mongoldoy.
CGM Mongoldoy. Before learned CGM. Okay, your petitions were granted with bail. Your Mr. Your one is
I'm for 30 and 31, Lordship.
30 and 31. You have
30
to-
is the anticipatory bill, Lordship. Here, Lordship, all these petitioners, Lordship, they, after the day's work, Lordship, they returned and they were there, they were taking tea, Lordship. And when this incident happened, Lordship, they left their vehicle and they ran away. So from their vehicle numbers, Lordship, they were implicated in the case, Lordship. They were nowhere connected with that.
They were in vehicle.
They came by their vehicle, Lordship, and after stopping that place, Lordship, it is like a chalk, Lordship, where they assemble and they take tea in the evening after returning. And so while they were there, Lordship, they parked their vehicle there, and this incident happened, Lordship, and there was hue and cry, and so everybody flew away from the space. So they also went away from their, Lordship, and after that, Lordship, their vehicles remained there, and from that vehicle numbers, Lordship, they were implicated.
They kept the vehicle and they ran away.
Yes, Lordship.
Why didn't you went through their vehicle also?
Lordship, because of that, it's everywhere the police was beating the people, Lordship, and so they ran away from there, Lordship. They are all Masons by profession.
Okay,
Lordship.
the number AB first you tell us AB.
Yes, in AB only I'm telling you.
How many petitioners are there in AB?
AB 6 petitioners, Lordship.
All were coming from where?
They were coming from the daily works, Lordship.
Lordship, in this regard, only petition number 1, Ainul Hawk. He is the son of the Gaubra, Lordship. And in his name also is there. It is stated that and his son, namely Ainul Hawk, did not allow me to open the door of the vehicle and used force to open the back door for escape of apprehended alleged accused persons.
Petitioner number 1.
Petition number 1. He is the son of the Gaubra.
Oh, Dadagiri. And about 2, 3, 4, 5 and
On
6.
that, Lordship, investigation is going on. Moreover, the witnesses have not named, but they are named in the FIR. I think, Lordship.
Yes, they are naming
Named in the FIR. But investigation is going on that.
Well, Lordship, this,
Specifically object on this, Lordship, because his name is there. In regard, witness have stated him, Lordship. And his role is also specified. But regarding the police has not named anyone in their statements, 161, Lordship, or rather 180, but their names are in the FIR. So
Okay,
investigation is
then
going
now
on.
we do one thing.
Lordship.
Let him appear before the IO. We'll give you them interim protection. Then the matter will come out with their role and all. But otherwise, they are though they are FNA. 1. For 1 also we are giving. Let the come the update case diary and then we'll see it. Simple quota considering the interim protection DD1. When it can be listed then for updated set case diary.
Lordship. 30 April.
30 April. Okay, you will be all are will be interim protection. Now tell us about 31.
31, he himself surrendered before the police, Lordship, because police were regularly visiting his place. He surrendered, and as on today, Lordship, he is 21 days in custody, Lordship. He is already thoroughly interrogated, Lordship.
As per him, he is surrendered. He surrendered. Is it? Is there any wrong step?
Abdul Jalil.
He is Abdul Jalil.
His statement is there. Lordship. I found it.
Although, Lordship, in the forwarding report, they have
Where is the forwarding report?
forwarding report is there, Lordship, at page 12. Forwarding report is not there, Lordship. I have annexed the 48 notice only, Lordship.
Page 12, 40.
11 Lordship, page 11, the 48 notice Lordship.
No. Page 12, we have,
12 is the forwarding report
Ah.
of those persons Lordship who were already arrested Lordship, that Lordship.
no, your petitioner is also arrested. Oh, he surrendered.
He surrendered Lordship. These were the petitioners Lordship who were in that vehicle Lordship. This subsequently they were arrested. So to show that Lordship, I have annexed this forwarding report.
You surrendered when you surrendered?
On 13/3/25 Lordship.
His statement is there.
Huh?
His statement is there.
So why are you saying about 47 you're saying?
Lordship,
You're also on 47 notice? Or
Lordship,
48
I-
notice?
47 notice has not been served. Only 48 Lordship.
No, as you have already surrendered knowing about the incident, 47 may not be there. 48 is there.
48 is.
Abdul Jalil.
Hmm.
Forwarding surrender forwarding हम लोगों का है.
Hmm.
21.
No, he again fled away from the police. He here আছে পুলিচে মোক আটক কৰে আৰু মোক গাড়ীত উঠাই লয় আৰু মোক থানালৈ লৈ যায় মুকুতেই গাঁৱৰ ভিৰ কৰি লৈ যাই থাকোতেই গাড়ী ৰখাই সোধা পোছা কৰে আৰু ঠেলা হেঁচা হয় আছামি চেক বুজি পলাও
That means on the date of
That-
incident, I think on the date of incident, he was taken up by the police.
So
Lordship.
you are now saying that he got surrendered.
Then subsequently he surrendered. Lordship. 13.
After death Lordship.
So you have not only committed once offense, then other also.
Lordship. That is why.
Also already he has been in custody.
Call for the updated case diary কৰি থওক 36 লাগে it may be considered on 34. You are already on 21 days now. It's a 60 days offense or
60 days.
I don't know, is it 60 days? What is the sections in fact?
Section 61. Yeah.
121 and 130.
So you have committed two offense. Rather, not one offense. You have committed two offense. As per your statement, your statement itself, it seems that you were taking out and then from there, Sek Buji Polai Jao, then again, you know that you have to again, you have got surrendered. That is the issue.
Subsequently he surrendered. Lordship. Subsequently he surrendered.
Okay, 34 will see to it. Both the matters. Updated case diary we call by
Regarding item 17, Lordship, there's an instruction, Lordship, charge sheet has not submitted, Lordship.
Okay, we'll see to it.
Without FSL charge sheet last day case day here the later instruction is submission
গপু এই হেৰি কৰিছে এই পুলিচে ধৰি লৈ যাই থাকোতে মাৰিছে
Yeah, I'm writing. Apply for yeah. Question list, item 1.
Please, your lordship, that case lordship. Here, lordship, the petitioner number 1 lordship. Against him, allegation is that he is a registered owner of a vehicle and his vehicle was used by the earlier arrested petitioner lordship. There is the accusation against that petitioner.
Mr. Borwa, we have received this one case diary early morning,
Related to item number 20 and
2021, yes.
2021.
There is
So
the
he is the,
allegation against the accused number 1 lordship in this petition that he is a registered owner of a vehicle and that vehicle was used by the co-accused lordship in transportation of the cattle lordship. There is the allegation he is a registered owner, but he did not use lordship, but the earlier arrested accused person have stated that they have used his vehicle lordship. There is the allegation against 1 and petitioner 2 lordship. The allegation against him is that he purchased 2 cattle lordship and that has been seized from his possession. Both are arrested lordship. And moreover, lordship, they were initially they were not named in the FIR. The later part during investigation, lordship, this thing has come up, lordship. And the moreover, the notice also not has been complied with, lordship 47. That apart, lordship, then considering the days, lordship, they are taken in custody and they are thoroughly interrogated. And further custodial detention might not be required, lordship, because the cattle has been already been seized from his possession, which he has purchased, and the vehicle, lordship, vehicle also seized from. As per the statement of the earlier arrested accused person.
Regarding my lord, Rasidul, my lord, petitioner number 1, my lord, I have objection, my lord. Because he is the main person, my lord, who stole that, my lord.
No, lordship, the forwarding report.
Theft, my lord, who committed the theft of the, my lord, cattle, my lord. And he sold to, my lord, that one, my lord, Bolayat Hussain, my lord. He is the main person, my lord, along with the others, my lord. And regarding the, my lord, regarding Tazal Islam, my lord, as per his statement, my lord, I have perused the case diary, my lord. He said, I purchased the vehicle from one, my lord,
Vehicle not cattle.
Amnarul Haq, my lord, but where from he brought the cattle, my lord, he do not know, my lord.
For
That is the statement of the, my lord, accused number, petitioner number 2, my lord. He purchased those cattle, my lord, but where from that, the person from whom he has purchased the cattle, he do not know, my lord. That is, my lord, amounting to, my lord, that, my lord, it is a, my lord, stolen one, my lord. And regarding procedural, my lord, I have objection, my lord.
Lordship will, for lordship satisfaction, lordship will kindly turn to page 20, lordship. What police has said at the time of arrest, lordship. Page 20 is the forwarding report of Honorable Haq, lordship. Procedural Haq, lordship, the petitioner number 1. Lordship, yes, the ground of arrest, lordship, the arrested accused person, namely Honorable Haq, he already has admitted that he and their gang used another 3 numbers of person vehicle for committing this type of offense, which was provided by his brother Procedural. That means, lordship, he is not involved in the crime, lordship. Personally, lordship. The vehicle was used, lordship, and the ground of arrest 2, lordship, during the investigation source included 1 Mohintos dialogue being registered number 4, which was recovered from the arrested accused Procedural Haq, lordship. Huh? There is the case, lordship. And 1 person is, as per his, another person is there, also gang member Procedural Ali. The PP might have gone to that Procedural Ali, lordship. He is the lifter of the cattle, lordship. Only my part is that my vehicle was used, lordship. And that was also unknowingly, lordship. My brother took the vehicle. Why?
Rashidul Ali is also there.
That is different person, lordship. He is a member of the gang, lordship. That might have PP have confirmed because.
No. In this case also, say Rashidul Ali is also involved.
No.
Ali
That is different person.
He is Haq, my lord.
I am Haq, lordship. I am the registered owner of the vehicle which my brother used to carry the vehicle to leave the cattle, lordship. That is the allegation against me as per the ground of arrest. And this is the fact, lordship. And the other person, the petitioner, he purchased it, lordship, unknowingly that the same cattle were stolen, one, lordship. They are, the vehicle also seized, cattle also seized, lordship, and they are behind the bar, lordship. Further custodial detention might not be required, lordship. And already we have taken custody, lordship. We have cooperated with the investigation, thoroughly interrogated. And local person, no chance of absconding. Lordship. At any point of time, we will make ourselves available for Lordship investigation of the case. Any condition Lordship may impose.
This is also petition from Purkasta, or you are
All
appealing?
Lordship. As he is on Itanagar and they are arrested, so he requested me to appear.
Production list one is not. Had Mr. S. Munir appearing on behalf of Mr. A.K. Purkasta, the counsel for the petitioner, and also have
It will do some
Mr. R.J. Borva, the learned edition PP, appearing on behalf of state respondent. And this is an application under section so and so in connection with so and so. Connection with so and so. When the case is at the stage of motion, the CD is produced as it was available, which was called for in connection with other case, other related case. Next pattern. Mr. Munir, the learned counsel for the petition submitted in this regard that the present accused petitioner number 1, who is the owner of the vehicle from which the cattle were alleged to have been recovered. His, as per allegation, his vehicle was used in commission of the offense of lifting the cattle. But he is no way related in the offense. However, it is an admitted fact that his vehicle was used in connection with the used by some co-accused persons. Further, he is in custody since last 18/3/2025. Thus, the IO got sufficient opportunity to interrogate him in custody. Next para, he further submitted that the accused petitioner number 2 is he only purchased 2 numbers of cattle from a person and on a bona fide belief, and it was not aware that the cattle which were purchased by him were stolen one. However, same commission, he is appealing the case submission in full. Next para, Mr. Borva, the learned edition PP submitted in this regard that the accused petitioner number 1 is involved in the alleged offense and he is the main cattle lifter. And
That is a, my lord, something mistake, my lord, because that is a Rosidul Ali, my lord. And he is, my lord, I am sorry, my lord, for that.
Procedural
The accused person is Rosidul Haq, my lord. What he has done, my lord, he hired a vehicle, my lord.
he is not the owner.
He is not the owner of the vehicle. He hired a vehicle which was used for, my lord, lifting the cattle, my lord.
He is not the registered owner.
No, he's not the vehicle. My lord, this is his statement, my lord. Also, I can- He hired a vehicle, my lord, which was used for lifting the cattle, my lord. One is Hawk and one is Ali, my lord. That is.
I'm sorry, Lordship, I made a wrong submission, Lordship. He is not the registered owner, Lordship. I'm extremely sorry, Lordship.
Register owner is somebody different, my lord. And when his vehicle was, my lord, intercepted by police, my lord, then register owner was, my lord, asked to appear before the police station, my lord. Then probably, my lord, register owner has implicated him, my lord, that he borrowed his vehicle, hired his vehicle. My lord.
Forwarding report also clearly says, Lordship, that first line, Lordship. The arrested accused, namely Honorable Hawk, admitted that he and their gang used to use another 3 vehicle or personal vehicle for committing this type of offense, which was provided by his brother, namely Rasul. This is the presentation opportunity.
Your submission on you. He register order to particular divo that he only provided only allegation against him that he provided the vehicle to the co-accused who committed the said offense. That part paragraph he is not connected anymore. And Mr. Borwa submitted that submitted that the accused petitioner number 1 hired the vehicle from other person and which was provided to the co-accused persons for committing the offense. Further, Mr. Borwa submitted that the petitioner number 2 purchased 2 cattle from a person without making any inquiry about the person or the cattle, and thus it reveals from the materials available in the case diary that he was aware that the cattle which were purchased by him were the stolen cattle. Mr. Borwa accordingly raised objection and submitted that further custodial interrogation may be required for purpose of investigation. Considering the submission made by learned counsel for both sides, materials available in the case diary, and also considering the length of detention already undergone by the accused petitioners, this court is of opinion that further custodial interrogation may not be required for the purpose of investigation. And I can this court. Okay, we are granted bail.
I'm extremely sorry.
CGM Lakhimpur, not Lakhimpur. CGM Lakhimpur.
It is just now handed for I have I'm extremely sorry. Much obliged, you lot. Much obliged. Much obliged.
May I please, Lord?
Is this here, LCS scan copy is it?
Yes, please.
Is it charge sheeted case?
Charge sheet case. Already someone has been issued in this case, Your Lordship. And next date is fixed on 8/4, Your Lordship.
So you were shown as an absconder or?
It was shown absconder by the police, but our court held that the police has no power to declare the petitioner as absconder. It is reflected in the order also, Your Lordship.
Which page?
Page number 35, Your Lordship. Annexure 4. I approached the learned trial court also, but my prayer was rejected for anticipatory bail. It is as page 36, Your Lordship.
It's a NDPS matter.
NDPS, Your Lordship. Under section 21C. Your Lordship.
By this order, your bail petition was also rejected.
Page 36, Your Lordship.
That was
Annexure
also
5.
anticipatory bail.
Anticipatory bail. So my humble prayer that Your Lordship, I will be allowed to go on bail on any condition, Your Lordship. I will appear before the trial court and face the trial, Your Lordship.
This is a commercial quantity bail. How can?
And so far, Your Lordship, the vehicle which was seized by the police, that vehicle also doesn't belong to him, and nothing has been recovered from his physical possession, Your Lordship. Only thing is that the vehicle was parked in front of his house, Your Lordship.
Hello, although my lord in the search sheet, he has been shown as an absconder, my lord, but trial court has issued summon to him, my lord.
Yes.
The trial court has rightly observed, my lord, the police has, my lord, no power to declare, my lord, accused person as absconder, my lord. It is the, my lord, only trial court can declare him absconder, my lord. Now in this case, my lord, when he has not been, my lord, when he has been shown as an absconder, my lord, now trial court, my lord, the duty is to, my lord, issue summon, my lord. The trial court issue summon, my lord. but he is not appearing, my lord. And his bail application has been rejected, that is page number 36. Lordship will kindly see, my lord. Page number 37, my lord, last paragraph. Revision of the case record of special NDPS case number so and so corresponding to Nonga PS case number so and so, which is already available in this court, reveals incriminating materials against the accused petitioner, hence prayer for previous bail is rejected, my lord. And my lord, page number 36, my lord, lordship may kindly see first, second, third, fourth paragraph, my lord. The allegation in the Azhar is registered on so and so in brief is that on that day a total number of 1,320 bottles of cough syrup of 100 ml each were recovered from a car kept in the house premises of the accused petitioner, in addition to other recovery. So how he can be protected, my lord, at this stage, my lord?
Let him appear, may not be kept for
The
the quantity of recovery is also a huge quantity.
That is 1,320 bottles is apart from the other recovery.
No, it was not from his position, also from other accused. Not from his position, not from his that vehicle.
No, no, that is kept in the house premises of the accused
So
petitioner.
there are other accused also here also. Specifically only 1,320 bottles.
Hmm? You are Mr. S. Decker.
S. Decker.
Heard Mr. S. Decker, the learned counsel for the petition. And also heard Mr. R.J. Burwa, the learned additional PP appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. Scan copy of the case record has already been received. Where is this? Next one. Mr. Decker, the learned counsel for the petitioner, submitted in this regard that the present accused petitioner is innocent and he is no way connected in the alleged offense. Further, no recovery was made from the conscious possession of the present accused petitioner, and the recovery was made from the vehicle which was parked in front of his house. Mr. Decker further submitted that the learned trial court below, the accused petitioner was though shown as an absconder. The learned trial court, learned special judge considered that the police has no power to declare a person as an absconder, and someone was issued against him. However, his prayer for bail, anticipatory bail, was rejected by the learned special judge. Learned additional session judge number special judge, learned special judge, so and so, by order dated 15/7/2024, and hence the present petition has to be filed seeking the order of pre-arrest bail. Next para. Mr. Borba, the learned additional PP, submitted in this regard that the huge quantity of contraband was recovered from the possession of the accused petitioner, and the learned trial court below also rejected his prayer, considering the huge quantity of recovery and other aspects of the case. However, the court only issued summon to the present accused petitioner, and accordingly, he may be directed to appear before the learned special judge and can apply for the regular bail. Next para, considering this submission made by learned counsel for the both sides, gravity of the offense, vis-a-vis the order of considering the order passed by the learned trial court below, dated 15/7/2024. I find that this is not a case for granting anticipatory bail at this stage. However, the petitioner is directed to appear before the learned special judge within 15 days from the date of order, with an application for regular bail, which may be considered in accordance with law. Till 15 days from the date of order, the no coercive action shall be taken against the present accused petitioner till 15 days from the date of order. Or order, it is course. You will be protected for 15 days.
Yes, Lord.
Then you appear before the learned trial judge.
Obligation.
Really taken up to some time, my lord. On behalf of SMC, he is on court number 17, my lord.
Who is appearing, Mr.? Discharge.
Actually, lordship senior is not required here
He's on
because the
list.
case is clear cut case.
No, whatever, he is taking time. When he will be
Yes, sir. He is appealing for an informant.
informant.
He is appearing for an informant and objection file I have received.
So for the time being only.
I mean, my lord.
37. 37 case there is not received, my lord. Allocation case there is call for, my lord. I am in interim, my lord.
You are on entry,
Interim.
CD not received. Issue reminder. Yes, Borwa, when it can be.
14-5.
14/5, 14/5. Interim be extended till next date of list.
All right.
38.
Yeah, please, your lordship. I am an interim minor. I was found with my employer was found with 14 carton liquor minor. Indian made foreign liquor minor. So I was an interim minor. Case has been received. I appeared there, minor. I record my statement also.
You are saying you're from your position, no liquor was recovered.
Nothing has been seized from my position, my lord. That is my employee, my lord. He was working in my wine shop, my lord.
You are the owner of the wine shop.
Yes, ma'am. I'm not the owner, my lord. I'm not the registered owner, but I'm the manager, man. The petitioner is the manager, man. And that person who was caught with the 14 bottles, my lord, cartons, he is the employee, my lord.
You are the manager.
I'm the manager, man. The wine shop is registered in another name, a lady.
Yes, Borwa, he appeared.
Yeah, my lord, statement recorded, my lord. And my lord, the allegation is that, my lord, this owner sorry liquor, my lord, it was not allowed to sell in Assam, my lord.
Mhm.
And he, my lord, brought this liquor to Assam, my lord, for the purpose of selling, my lord.
Mhm.
Whether, my lord, he was not caught with the, my lord, liquor, my lord, but later, my lord, he was directed to appear, my lord, before the police, my lord. Then, my lord, probably he has filed his bail application, my lord.
My wine shop is in the border area, my lord. It's Gopur. It's nearby Arunachal.
So it's very easy for you
Yes,
to bring liquor from Arunachal.
I'm only the manager, man.
He is not allowed, my lord. So being a manager, my lord, how can he, my lord, bring home,
There
liquor
was-
to, my lord, which are not
Yes,
prohibited in Assam, my lord. He
No.
cannot sell in Assam, my lord.
No. You are not Mr. Algogo, your good name?
No, I'm Dibora, man.
Borwa. Your name is not reflected
No,
in
man.
here.
I'm on behalf of El Government.
Had Mr. Borwa appearing on behalf of Mr. Algogo, the learned counsel for the petition. Also had Mr. R.J. Borwa, the learned additional PP so and so. And this is an application on the section so and so. CD receipt. It is submitted by Mr. Bora that after obtaining the interim pre-arrest bail, the accused petitioner had already appeared before the IU and extended his cooperation in the further investigation, of this case. Further, he submitted that nothing has been seized from the possession of the present accused petitioner. However, as per allegation, the 14 numbers of liquor was recovered from the possession of one of the employee who works in the said wine shop. Mr. The petition full stop, the petitioner is still ready and willing to cooperate the IO in further investigation of this case if he is granted with so and so. Mr. Borwa, the learned additional PP submitted in this regard that the petitioner appeared before the IO and his statement is also recorded on section 164 CRPC. From the materials, it is also seen that it also available that the owner-chili liquors were brought to Assam for illegal, to sell it illegally. However, the present petition, there was no recovery from the present accused petition.
Because when the vehicle was found in abandoned condition, my lord, driver fled away, my lord.
And the liquor was recovered from the vehicle, which was found in abandoned condition. Next, madam. Considering the submission so and so, conduct of the accused petitioner, preserves the materials available in the case diary. I find that the custodial interrogation may not be necessary for the purpose of investigation. Our absolute bail is 2012 to 2025. That means. Yes, obviously.
And my objection may be recorded, my lord.
Yes. 12 to 2025 is made by absolute.
Obligation. Obligation.
Appear before the IO and cooperate
Yes,
if necessary.
Obligation.
29.
May of Lordship. Lordship, FIR case 12 Lordship. 2021 B Lordship. Divorce call for Lordship. Long affair Lordship. Allegation 7 grams of suspected brown sugar recovered from my home Lordship. Already two person arrested Lordship. Actually, they are revision bail Lordship.
So 7 alleged in that 7 grams
7
of
grams.
heroin from your
Recovered
position.
from my
Intermediate
home Lordship. Not position, from my home Lordship.
Yes, this is
As per
intermediate.
statement of two accused person, searching my home Lordship, one Amir Ali and MD Ahmed Ali, they are arrested actually revision bail Lordship. But I need to the FIR Lordship, I have not entered the schedule list Lordship. Suspected brown sugar in transparent plastic pouch, gross weight 7 grams. Along with the plastic pouch Lordship, it's only 7 grams Lordship. So I am ready to cooperate Lordship. Not for me personally, only what's home Lordship. I am ready to cooperate Lordship with a local boy Lordship. Is a business by commission Lordship.
So why you kept this 7 grams of heroin in your house?
Lordship, this is allegation Lordship, not
No
from my
allegation,
person.
otherwise you are not a consumer.
Lordship,
Are
maybe-
you?
Lordship, maybe maybe he is a consumer Lordship, maybe. But only 7 grams, considering that small quantity Lordship. Maybe
My
small
lord.
quantity Lordship.
We have received the case diary, my lord, and from the seizure list, my lord, specifically mentioned, my lord, in the seizure list, from the house of Maidul Ali, my lord, son of so and so, then my lord, date and time is there, my lord. Two persons were, my lord, interrogated, my lord. They have implicated him, my lord, that some contraband still remain in the house of my lord, this Maidul Ali, my lord. Then police came and searched his house, my lord. When police came, my lord, this person fled away, my lord, and this contraband was recovered, my lord. So I strictly, my lord, I oppose this bail application, my lord. Because
Lordship,
he is a
ready to
peddler, my
cooperate
lord.
Lordship. Only 7 grams Lordship, ready to cooperate Lordship. Lordship, maybe
This is the anticipated bail, my lord. It is not a regular bail, my lord. And it's an intermediate quantity, my lord, not small also, my lord.
Lordship, along with post Lordship, along with packet Lordship. If packet is removed Lordship, maybe a decrease weight Lordship. Along with packet 7 grams Lordship. Along with packet Lordship. That's clearly mentioned Lordship. Sugar in transparent plastic pouch, gross weight 7 grams Lordship. Along with packet. If packet is removed, it may be decrease Lordship, maybe 4
Anyway,
grams.
my lord, this is not a, my lord, case for granting him, my lord, 3 days bail.
No, you want to say if suppose it's removed, it's small quantity, then is
It's
it
okay,
is it available?
Available is Lordship. No. This one is
So there is
up to 1 year Lordship. Up to 1 year.
anything that the acts or the statutes itself says that it is a non-bailable offense.
Lordship,
And all
up to 1 year Lordship, then punishment
No,
will be up to 1
no,
year.
that is the view of some other high courts, not from our high courts, and
Yes,
we are not.
that is true Lordship. That is true Lordship.
Anyway, okay then.
I am ready to cooperate Lordship.
heard Mr. A.K. Ahmed, the learned counsel for the petition, and also heard Mr. R.J. Burva, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so, CD receipt, various the same. It is submitted by Mr. Akan, the learned counsel, the Ahmed, the learned counsel for the petitioner, that as per allegation, only 7 grams of heroin was recovered from the person of from the house of the accused petitioner. And there is no and then there was no recovery from the conscious person of the present accused petitioner. Further, he submitted that the quantity of heroin is stated to be 7 grams, along with the transparent plastic packets, and there is probability that the weight may be less than 7 grams if the plastic container is removed. Further, he submitted that he is ready and willing to cooperate the IO in the investigation of this case if he is granted with the privilege of pre-arrest bail. Next one, Mr. Borwa, the learned additional PP submitted in this regard that from the Caesar list and from the materials available in the case diary, it is seen that the recovery, the heroin was, the said contraband was recovered from the possession of the accused petitioner. And full stop. During the interrogation of 2 other co-accused person, it was found that who interrogation so and so. It was stated that the heroin is some quantity of heroin is still available in the house of the present petitioner, and accordingly, when police search the contraband was found in the house of the accused petitioner, and during that time the accused petitioner fled away from his house and he absconded. Further, Mr. Borwa submitted that he is a drug peddler and custodial interrogation of the present petitioner will be required in the interest of the investigation. Next paragraph. Considering the submission made by learned counsel for both sides, materials available in the case diary, and other aspects of the case, I find that custodial interrogation may be required for the interest of the investigation, and accordingly, I do not find it a fit case to extend the privilege of pre-arrest bail to the present accused petitioner. And accordingly, this same stands rejected. Your petition stands rejected.
Obviously.
41.
May I plead, Your Lordship? Lordship, charge sheet has been already filed, but the apprehension is that, my lord, there are 2 sections, sessions tribal case, my lord. So if we appear before the committal court, there is the apprehension of putting them behind the bar, my lord. That's why we are before this honorable court for anticipatory bail. Already search sheet has been filed, the investigation has been completed, nothing else, my lord.
How many petitions? 2.
3, my lord. And all are from the same family.
Which one is the bailable or non-bailable?
My lord,
17.
section 76, sessions tribal, my lord, and 117, subclause 4, these 2 are sessions tribal.
So you were shown as an absconder.
Yes, my lord, here in charge sheet, shown as an absconder. Huh? The sessions tribal, okay.
all the petitioners are ready to face the trial, but the apprehension is that if they appear before the committal court, so definitely the committal court will put them behind the bar.
So my question is that, my lord, why they have not cooperated with the investigation, my lord? Now they have not cooperated with the investigation, my lord. They remain absconder, they absconded themselves, my lord. And now, my lord, when the charge sheet has been submitted, my lord, now they are coming with this period bail application. My humble submission, let them appear, my lord, but my lord, let the trial court pass necessary orders in accordance with law.
It's not a thing that we are not cooperating. Definitely we will cooperate. But the thing is that if we approach the police, definitely the police will put them behind the bar. Police
That
will
means you are
arrest.
not cooperating.
My lord,
That's what means you are not cooperating.
my lord, that's why the provision of anticipatory bail is there, my lord.
Whether they have approached before this honorable court, my lord, or any other.
Before filing of the charge sheet also, or before at the time of investigation, you could have approached if there is any apprehension, but at that time, most probably they have not approached.
My lord, they have approached before the sessions court.
That was rejected.
Yes, but that was rejected, my lord.
Report came not rejected,
report
came the charge sheet has
A report came, my lord. Charge sheet has been filed. That's why it was rejected, my lord.
Now, what is the case? Your case is, against you, the,
My lord, if you look at the FIR, my lord.
no, against you, what is the order at present? After charge sheet?
Now, it has been fixed for appearance, my lord, on 8 May. 8 May.
You have not annexed the order also.
My lord,
Last order?
last order after filing of that notice was someone was issued, my lord. After filing of this application, my lord, anticipatory bail application.
Then how we know that nothing is there before us now?
They approve the learned session judge, my lord, after filing of the charges, my lord. Definitely session judge will, my lord.
No, my lord, before charge sheet, before filing the charge sheet, we approached the session, learned session judge. Their report came that charge sheet has been filed. Then we came to know that charge sheet has been filed.
Then file the order sheet.
My lord,
We don't
and
know.
this, before filing this, this instant anticipatory bail application, someone was not issued. It was later on issued, my lord. That's why we have not annexed it. And we could not have annexed it because.
So we don't know what is the stage.
My
of
lord,
this now.
my lord.
What is with you now? At present?
That I am, my lord, I am fairly submitting, but I am not paid of the scheme with you, my lord, in this case.
We have NPR'd, my lord, on 8th of May. It has been fixed for appearance. Before the CGM Baksa. No. It will come to the it will help for a certain.
As per the last order, that is, my lord, 10/1/2025, my lord. Cognizance taken, my lord, and last date was fixed on 13/3/2025 for appearance, my lord.
Someone was issued.
Yes, my lord. Someone was. 13/3.
13/3.
8/5 is fixed.
13/3 rupees or 8/5 is no, it will be helpful.
No. You submit for yes. And this is the part of money. And they can't do it.
Only these 21% are absconding, my lord. Other 21%, they have already, my lord, appeared, my lord, and they were on court bail, my lord.
But
Others are code on code bail.
Others 21%, but they have court.
Others are also same family members.
Same,
my lord.
Same family members.
The same family members, my lord, their surname is same, my lord, whether, my lord, they are.
Same family members. My lord, we are ready to face the trial, but the anxiety, the apprehension is that if we appear before the committal court, so since there are two sections, my lord, sessions tribal. So at
So we may give you some interim protection.
my lord,
We'll record your submission and we may give you some interim protection. Up to 15 days we'll do.
my lord, that will not suffice the purpose, my lord. Because ultimately they have to appear before the trial court, and trial court, since there are two sections, the committal court will not going to indulge that provision, my lord.
Borwa, is it a case of anticipatory?
And in this case, usually even this honorable court also earlier used to issue anticipatory bail application, granted anticipatory bail application, my lord. And there are some other orders of this honorable court, collateral benches of this honorable court also.
Question is that, my lord, they are absconding, my lord. It is not that, my lord, they were very much present, but police could not find them, my lord. So since when they are not cooperating with the investigation now,
Even
my
if
lord.
even
Now,
if
after filing of the search sheet, my lord, they have come with the anticipatory bail.
no, that is wrong, my lord. We have come before the not before this, before the learned district judge, even before filing the charge sheet.
No,
This
that-
has been after charge sheet, but we have approached the district judge before filing the charge sheet, my lord.
Question is that, my lord, search is submitted on 31/12/2024. And Lano session judge, my lord, rejected their bail application on 16/1/2025, my lord. Page number 33, my lord. Last
But-
page of the bail application.
But filed, it was prior, my lord. And that time we were not aware that charge sheet has been filed. Who will inform us that charge sheet has been filed?
My submission, my lord, blanket protection cannot be granted, my lord, since they are absconding. So my humble submission will be recommended. It will happen.
Heard Mr. PM Decker, the learned counsel for the petitioner. No, name is not there. Name is not there. Name is not there. BM Decker. Learned counsel for the petitioner. And also heard Mr. R.J. Borwa, the learned additional PP, appearing on behalf of state respondents. So and so. This is an application under section so and so in connection with so and so. It is next para. A scan copy of the case record has already received. Likhiba. It is submitted by Mr. Decker that all the accused petitions belong to same one family, and they are ready and willing to appear before the learned trial court below and to face the trial. But as there are two sections which were as the section 76/117 subsection 4 are non-bailable and session triable, they are in apprehension that they may be arrested if they appear before the learned committal court. If further submitted that the other family members of the present accused petitioners were already appeared and they are on bail. However, these accused petitioners also moved an application for seeking anticipatory bail prior to filing of the charge sheet. But during the pendency of the said bail application, it has came to the notice of the court that charge sheet has already been submitted, and accordingly the prayer for anticipatory bail was rejected. By order dated 16/1/2025 by the learned session judge Baksa Mosadpur. Mr. Decker, however, submitted that at the time of filing the earlier anticipatory bail application, it was not within the knowledge that this CS has already been filed, and with a view to cooperate in the investigation, they applied for the anticipatory bail. Poster. However, the present all the petitioners are ready and willing to appear before the learned trial court bureau and to appear on each and every date to be fixed by the court. Next, Mr. Borwa, the learned edition PP submitted in this regard that the other accused persons have already appeared before the IO and they are on regular bail, except these three petitioners who were shown as an absconder in the charge sheet. During the entire period of investigation, they have not cooperated the IO. And after filing of the charge sheet only, they have come with a petition for anticipatory bail. In that context, and accordingly, Mr. Borwa raised objection and submitted that a blanket protection cannot be given to the present accused petitioners. In this context, Mr. Dekha submitted that they were already appeared before the learned session judge, as stated above, prior to the filing of the charge sheet. However, the prayer was not considered as the charge sheet was already filed. Next, considering the entire facts and circumstances of this case, the present petitioners are hereby I find it a big case to extend the privilege of pre-arrest bail to the present petitioners. And in the event of arrest, these accused petitioners will be granted with the prior prayer for interceptory bail. Will be yes later. And in the event of arrest, they will be allowed to so and so now. And further, the petitioners are hereby directed to appear before the learned trial court below with an appropriate application for bail, for regular bail, which may be considered in accordance with law. Okay, you are granted with interim protection till you appear before the learned trial court below.
My lord, that will not.
Anticipated bail we have granted you.
My lord, much obliged, my lord.
With a direction to appear before the learned court below with a for regular bail.
For
Regular bail, this is not regular bail. No?
my lord, and that may be considered, my lord.
In accordance with law.
And security amount, my lord.
It amounted 2,000 with one security.
My lord, will appear before the learned trial court, my lord, now. Because investigation has already been completed, so we have to appear before the trial court, my lord, committal court.
Your protection is given in the event of any arrest, but you have to appear before the learned trial court below with a regular application for bail. That may be considered. Okay.
Much obliged, my lord.
42.
May it please your lordship, this
Yes.
case pertains to the Wildlife Protection Act, my lord.
Oh, acha,
I am on interim protection. I have appeared before the investigating officer.
Mr. Sharma is looking after.
They are not present today, my lord. Interim or assignment?
Interim.
Sharma and Gogoi is also looking.
So D Gogoi.
And one Bhattakur is also there. He is
I
not.
Bhattakur.
I Bhattakur.
Yes. Baaki thoda sa फायदे में
Kitna
he is on
fix it on-
interim, my lord, then some other day, man. I cannot
But
submit.
we don't know. Do you have any information regarding any receipt of case diary, record or whatever? Is there any?
No, your lordship.
We don't
I
have.
asked, but then they said I'll get the information. I have not met them. There.
From Mr. S.
Yes, they.
D. Heard Mr. 42, huh? Heard Mr. S. D. The learned counsel for the petitioner. It is informed by additional PP, Mr. Borwa, that the learned special PP, so and so, but the learned special PP is not available in the court today. Full stop. However, it is submitted by Mr. Day that he is on interim pre-arrest bail. Next para, considering his submission, let the matter be listed after view vacation. After view vacation, on a date to be fixed by the registry. Until then, the petitioner, the interim protection of the prudent petitioner be extended. But the question is that have you appeared?
I have
after
appeared,
obtaining-
Your Lordship.
Okay,
Much obliged.
after view.
43.
43, my lord, we have received the case diary, my lord. This accused person, he is on interim, my lord. But my lord, his statement is not in the case diary, my lord. So may I pray, my lord, to follow the up-to-date case diary, my lord. We have to return the case.
You're here from, it is seen that his interim was granted on 2002.
22, my lord.
Yes,
And on the last entry, my lord, although last entry is on 24/2, my lord, but there is no reflection whether he has appeared or not, my lord.
As per his instruction, he has appeared there, my lord. He has gone to the police station twice, my lord. And the first instance, he cannot meet the IO. The second instance, he told me that he has given his statement. Yeah.
he given.
Yes, but it's not in record, my lord. So after the case study may be record, my lord.
Had Mr. D. Bora, the learned counsel for the petition. Also had Mr. R.J. Purva, the learned additional VP, appearing on behalf of state respondent. It is submitted next para. It is submitted by Mr. Purva that those CD is received. It is not updated one, and the last entry was on 24/02/2025. And the statement of the present accused petitioner is not available in the case diary, though in the case diary. And accordingly, he submitted that updated case diary may be called for. Next para, Mr. Bora submitted in this regard that as per his instructions, the petitioner has already appeared before the IO in 2 occasions, and his statement is also recorded. In view of this, later updated case diary be called for. And the IO is directed to furnish the copy of the statement of the present petitioner, if already recorded. Return the case diary. List accordingly, yes, board. List accordingly on 2/5/2025. And till date, the petitioner will be, an interim protection of the petitioner will be, interim order of the petitioner will be extended till next day.
God bless me. God bless.
44.
My lord, we have received the case diary, my lord. There is a note of the investigating officer, my lord, that there is no such incriminating materials against this petitioner. So he is not interim, my lord. He has also appeared before the IO.
Mr. I.C. Decker. Heard Mr. I.C. Decker, the learned counsel for the petition. And also heard Mr. R.J. Burga, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. CD received, Perus decision. It is full stop. It is submitted by Mr. Decker that the present accused petitioner has already appeared before the IO and cooperated in the investigation after obtaining the order of interim pre-arrest bail dated 24/02/2025. Next, Mr. Borwa submitted that the petitioner is cooperating in the investigation and considering the materials in the case record, his prayer may be considered. Case diary, sorry, may be considered. Hearing the submission of both the petitioners and also considering the materials available in the case diary. Available in the case diary, conduct of the accused petitioner, the interim bill granted to the accused petitioner dated 24/02/2025 is hereby made absolute with same terms and conditions. Okay. Already.
46.
Yeah, please, your lordship. This is a POSCO, my lord, and there's a POSCO, my lord, by
It's a case of POXO.
POSCO, my lord. And so,
Why underside is not there?
Lordship,
Other-
I have taken in, asked the office lordship, they have stated that on 17/3/2025 from our office, notice has been taken by postman lordship. But we have not received whether service has been completed or not.
And in fact, my lord, I have also annexed in this case, my lord, the HLCC certificate of the victim guard, my lord. Your lordship may kindly peruse this at page.
Now see, these are there, but this it is section 6 of the POXO. We are not in a position. You take instructions there regarding the service of notice. I don't know, it's a per office note only, it is there that state was received and your office seal is there.
Lordship, it is there, lordship.
It is there.
I have asked office. They have stated that on 17/3/2025 it has been taken. But generally, they give us the notice, lordship, the serving report to us through WhatsApp or in our office.
By OC concern.
OC concern, they usually, lordship. We know, don't need to ask, lordship, they usually give it to us. But in why I haven't taken instruction on that, lordship. Because sometimes I have asked my office man, lordship, the clerk, but yesterday that they have not taken the phone of him, lordship. He may be busy somewhere, lordship. The IO.
In that case, my lord, it may be fixed prior to view vacation, my lord. Since we just obtained instruction, otherwise your lordship may also appoint the amicus curiae also, my lord.
No, we are not, we don't know whether this, they may appoint otherwise
That-
also.
that's-
If it comes written or if it is services completed, definitely will appoint an amicus. You
If
are
possible,
Mr.
your lordship may
I'll
kindly prior to vacation, my lord.
prior to vacation. No, not at all possible. Not at all possible.
I-
You're Mr. Alam?
I alum, my lord.
Alam. Heard Mr. I Alam, so and so. And also heard Mr. KK Das, so and so. It is submitted by Mr. Das that on inquiry made by him, it is stated that from the office of no, you make an inquiry otherwise. Submitted that he will make a further inquiry regarding the service of notice on respond number 2. Otherwise, you have received the case diary.
Yes, there is issue.
CD already received. We want to retain it or what to do?
It will be.
For retaining, it will be after
minimum days,
review vacation.
lordship.
But one other point is there, if it is returned back, it may not reach also others time.
But
That-
we'll ask lordship, the police officer, I
Mm.
will call that after whatever date may be fixed, lordship,
Mm.
have to be given. Okay.
So you are going to return it now?
Return, lordship.
Return the case diary and call for the updated one. Here when it can be listed then.
On 29th of April, lordship. April, 29th of April.
My lord, I am on AB, my lord. So in 29, it will be a much rather matter.
Okay,
And
okay.
there are so many people who were not even involved in this, as Gaon Panchayat president and other villagers, my lord.
I am taking that date
Almost
because
14 to
lordship
15
has stated
persons
that
are
no
there.
date is also, it is full, lordship. That is.
Prior view.
No, lordship, after Bihu also 21, 22, 20.
Immediately after Bihu, my lord.
That is why, lordship.
22 full of matters, no?
That is why,
Full
lordship.
matters are 21,
That
20.
is why, lordship.
22, my lord, if possible.
23, 24, 24 both are 700, 23 also. Yes. 25. 25 can be. Okay,
My lord.
25.
We'll return back the CD, lordship.
Yes, return back the city, call the updated. Yes.
48.
What is the position?
In
48.
this case also, Lordship, I have been informed that today only, the notice went away from our office, Lordship. And moreover, 163 statement, 164 statement is there, it implicates Lordship.
So here also we have to return back otherwise.
Petitioner is also not there.
Petitioner remain absent on call. Heard Mr. K.K. Das, learning counsel for the petitioner. He submitted that CD is already received, however, the service is not yet completed on respond number 2. Mr. Das will make an inquiry in regards to the service of notice on respond number 2. Return back the case record. A case diary calling for the updated one, list accordingly after BO vacation. Okay, after BO vacation will do. Will not mention any date after BO.
Timing 36.
May I please, your Lordship?
Yes.
Lordship, here what happened, Lordship, by filing an affidavit in opposition, they have annexed the birth certificate of the victim girl. And by filing this additional objection, they are saying that I have misleaded this court, I have made false statement. Now, Lordship may kindly peruse the FIR, page number 12. Yes, the victim is minor. Now I admit because they have annexed the birth certificate. But so far as misleading part, Lordship may kindly peruse page number 12. Here, the FIR contains the date of birth in Assamese 1411. Thereafter, it is 200 and English 8 is written. And as the date and month is written in Assamese, how can I guess that her date of birth here is 2008? So I never misleaded this court, my lord. I honestly submitted as per this FIR, as all the language in Assamese, first date and month both are in Assamese. That's why I submitted honestly and interim granted. I appeared, statement recorded. Thereafter, now they have annexed the birth certificate. As per this birth certificate, yes, she is victim, she is minor. So I am leaving it up to your lordship.
But specifically, I have mentioned age is 16. Specifically mentioned the age is 16.
Where in FIR?
Yeah, yes.
Yes, lordship.
It is also.
It is written, but I thought, lordship, that the date is specifically given. I have gone through the date, lordship. I have gone through the date.
My lord, school certificate, HL2 certificate, birth certificate, and my lord, Aadhaar card, everything, my lord, date is same. So my lord, the card was recovered, kidnapped, and it may be injected.
It is.
There.
Your objection is where is the objection? I have no objection to put a sound in.
Objection is there.
Actually, lordship, it is a case of kidnapping and she is recovered, not a case of POXO, isn't it?
Naturally, minor card, when you kidnap, will not be possible to be added. How can you say like that?
Girl herself along with the court.
Not? Out of time, it will be okay.
I have given, I filed it, but
Earlier you were on interim.
Yes, lordship, because of this year, because of the FIR clearly states in Assamese, it is her date of birth is 14/11/2004. I thought it 2004 because it is the date is in Assamese, month is in Assamese, but year is written in English. How can I guess that this year is written in English? Now they have annexed one birth certificate. I don't know why. Is it true or false?
But as per this birth certificate, she is minor. So lordship, I am leaving it up to your lordship.
Not only birth certificate, we have given the Aadhaar card certificate, then school certificate, that is HL certificate, everything is same birth date of birth. 14/11/2008.
Yes, yes, yes.
And PD also has come back.
ইয়াতে তো এখনই লগাইছে অকল birth certificate.
আপনার খবর কেন এখনই দিচ্ছে আমি তো সবই ফলস বুলি কই দিই ভয় লাগে মোৰ বাকি আদালত
False বুলি কোৱা নাই।
The cases registered under 137(2) or
Yes, lordship.
Kidnapping, my lord.
kidnapping was.
Yes, lordship, kidnapping case.
And is there any addition of?
Yes, madam, but what I'm submitting, my lord. When the case was, my lord, registered, my lord, it was registered on, because, my lord, the victim card which says, my lord, kidnapped by the, my lord, accused person, my lord. Now, my lord, when the victim was recovered, when her statement was recorded, my lord, the police found, investigating officer found that, my lord, it attacks section 6 of POCSO Act, my lord. That is why, my lord, section 6 of POCSO Act was added, my lord. In the meantime, my lord, while after registering the case, my lord, the accused petitioner approached this honorable court and he took an interim, my lord. And pursuant to that interim protection, my lord, he appeared before the IO, his statement recorded, my lord. Now the question is that, my lord, as per the victim statement, my lord, although she has not said anything against, my lord, but whether her consent has to be, my lord, valid consent or invalid, that has to be looked into, my lord.
Lordship, let me.
Because, because, my lord, he has stated, my lord, during her stay with the accused person, my lord, they involved in physical relation, my lord. So that even if she consented also, my lord, that will not amount to, my lord, valid consent, my lord, because her age is, my lord, about 16 years of age, my lord. And, my lord, admittedly, my lord, her birth certificate has been, my lord, seized by the investigating officer, my lord, and she is minor, my lord. So it affects, my lord, section 6 of POCSO. But 183 statement, my lord, she has not said anything, my lord, against the person. There is a, my lord, big love affairs, my lord, because my brothers of the, my lord, victim girl, my lord, they have seen them, my lord, that is why they have eloped, and they eloped to Shillong, my lord, and they stayed there.
Lordship, I want to submit only one thing in my last submission, lordship. They are neighbors, lordship. Suppose, lordship, today he sent to the jail, and enmity will be there always, lordship. They are neighbors, there are love affairs, it is true. And suppose after attaining the age, marriage will also be conducted between the parties, to my information. And suppose they are neighbor also, lordship. Titles are also same. And lordship, if he is sent to jail, the girl is recovered. Now she is at her home. So lordship, as I was in interim, let me grant absolute lordship in due course of time. I will appear and face the trial if required, lordship. Because I have appeared and she is recovered. Lordship, nothing to do to keep me in behind the bar, lordship. This is my humble submission.
Yes, Mr.
Law is settled, my lord. Law is settled, my lord. When she's a minor, my lord, my learned friend have to face the consequences, my lord. She's a my lord, and even if, as per the diary medical report, the physical relation was all established, it is another heinous offense he has committed with the minor girl, taking into consideration that and kidnapped her and taken to Shillong, my lord, from the lawful guardian.
She herself who allow.
Yes, she herself cannot allow unless you take. That is the consent. Consent, minor consent is no consent. It is not my decision. It is the decision of the Apex Court, High Court. This is settled law. So, my lord, I pray that bail should not be made absolute. Let him go to jail and he should approach the trial court for regular bail. Let him surrender.
What will happen to?
Apparently nothing. It will be a lesson to others. Nobody would dare to kidnap the minor girl. That's why law has been framed. We cannot give the indulgence of such type of things.
Even my mother was married at the age of 40 years.
Yes, that is the.
At her 16 years, I was born.
No. Those days, those things, yes. Now that law.
Now you cannot say, yes, 16 years old girl is measured.
Now child marriage.
File an FIR against my father.
No, no, with respect, don't say like that.
No, against your grandfather, one FIR has to be lodged now.
Yes, yes.
He wants to. So Lordship, I am on interim Lordship, no violation is there and she is my neighbor. And what purpose will serve to keep a boy in behind the bar, Lordship?
Purpose will be served, he will be restrained from doing these things like in future.
Already he has learned a lesson.
He has not learned it. Why?
Learned a lesson because he engaged, a poor person engaged a lawyer in high court.
Pleasure, brother, it's a
He
pleasure.
appeared in police station.
Appeared with the protection.
For 2 days, he
Appeared with the protection.
seated in the police station and
But one question that I want to say, obviously minor consent cannot be considered as a consent, that is effectively. But the bail bond girl under the impression that girl was a major.
Because
And
the
I
subject-
won't-
My learned friend has admitted that by wrong, I have wrongly. have
But I won't question the Mr. Soma also, because in the FIR, if you go by the FIR,
Yes,
2211 is also in SMS.
yes.
And suddenly if 8 is 4 is
Up to
8,
what
then
is
what to do? Obviously 16 years is there, but it cannot be said that it is a misleading statement, because
I
in
straightly go by
2011
the date.
all are in SMEs and abruptly 2008 is in English form. So
But at the same time, your lordship will definitely appreciate that. Is a father was in a puzzle time at that time, guard has gone, what to write, what, he is a illiterate man, somebody has written it. That is also, all these things have to be considered. At least, my lord, let the matter be sent to the trial judge, my lord. Let him do, consider it, let him surrender. I hope he will
charge sheet
consider,
is not there.
because it will, if your lordship grant it, my lord, with all respect, my lord, it will be a settled decision of the High Court, my lord. The minor has been granted bail.
Heard Mr. G. Somo, the learned counsel for the petition, and also heard Mr. S.C. Biswas, the learned counsel appearing for the respondent public informant. And now Mr. Borga, the learned additional PP, appearing on behalf of state respondent number 1. This is an application under section so and so in connection with so and so. CD receipt, bills the same. Mr. Somo, the learned counsel for the petition, submitted in this regard that in pursuant to interim pre-arrest bill dated 2012-2024, he already appeared before the IL, cooperated in investigation, and his statement is also recorded under section 161 CRPC. And 6160 RPC. He further submitted that he is still ready and willing to cooperate the IO in further investigation of this case. Mr. Somo further submitted that it was under his impression that the date of birth of the child, the victim was on 14/11/2004, which was written in an assembly in the vernacular language in FIR. But presently it has come to the knowledge of the court, that at the relevant time of incident, the victim was admittedly a minor. He further submitted that there was no question of kidnapping, as the girl went eloped with him by herself and out of love and affairs, and he is still ready to accept the girl when she attains her maturity. Next para, Mr. Borba, the learned additional PP, submitted in this regard that admittedly the girl was a minor at the relevant time of incident, and hence her consent cannot be accepted as a legal consent, even if it is considered that she eloped with the boy out of love affairs or stayed together with the accused, together the accused as a husband and wife. Further, he submitted that though initially the case was registered under section 137, subsection 2 BNS, but during investigation it has come during investigation it has come to the notice that there was physical relationship between the parties, and accordingly section 6 POCSO is also added. Mr. Borwa accordingly raised objection and submitted that it cannot be a case for anticipatory bail. Next para. Mr. Biswas, the learned counsel appearing for the respondent number 2, also submitted in this regard that consent of the minor cannot be considered as a valid consent. And in the same time, he also produced all the documents like the birth certificate, school certificate, etc., which also shows that the victim was a minor at the relevant time of incident. Mr. Biswas also accordingly raised objection and submitted that it is not at all a fit case to consider the pre-arrest bail prayer of the present petition. Next para, considering the entire facts and circumstances of this case, statement made by the victim under section 183 CRPC, and the CRPC, it is seen that she has not brought the allegation, any allegation against the present petitioner, though it is admitted that she went with the accused to Shillong and had physical relationship with him. It is also a fact that the consent of a minor cannot be considered as a valid consent. Valid consent and valid consent, and in the present case, it is the admitted fact that the victim was a minor at the relevant time of incident. However, considering the matters in the case diary, what do you say? Just for a second. Find it a fit case to extend the privilege of pre-arrest bail to the present accused petitioner. However, with a direction to the accused petitioner to cooperate the IO in further investigation of this case. I find that custodial interrogation is not necessary in this case, and accordingly, I find it a fit case to extend the privilege of pre-arrest bail to the present accused petitioner. considering the materials দিব দেই তাৰ ঘটনা দিব considering the materials available in the case diary especially considering the statement made by the victim under section 183 CRPC তাৰ মাজত লগাই দিব okay you are granted to entry period 2012-2024 is hereby made absolute.
For orders, item 49.
May I please to Lord?
Forty-nine.
49.
Here, government advocate was appearing, na?
PP is appearing and also private resident number 4 is appearing.
No, PP is appearing, government advocate is also appearing, I think. One order I have seen where
Yes,
government
in
advocate
respect
was
to
also asked.
state is the party is there.
It is a criminal matter, government of Assam civil department, they appear for.
Government of Assam? Government of Assam civil, yes. They will appear.
There is appearing.
Their name is, yeah, Assam has been sold.
GA Assam has been shown, yes.
The issue is, my lord, is
Why it is in order column, in fact? LCR was received, I think.
LCR
LCR
received. Space, my lord, I am the owner of the cows, my lord. 13 numbers of cows.
Your this ox, etc., they are still alive. Oh.
Still alive, my lord. And it's apparently, my lord, apparently there is a gross injustice made against me. In the year 2021, I am the owner. A false case was registered. I was arrested just before Eid, my lord, saying that it was been stolen. However, no stolen, I have purchased. And I was taken up. Thereafter, my lord, bail was granted. I, my lord, appeared face trial. The case was ended with acquittal. Court ordered the Gaushala, ordered the police to hand over these cows. Still late. Despite this order, cows are not handed over. Accordingly,
Cows are in possession of one I think one foundation, na?
Gaushala, that
Gaushala.
Gaushala, my lord, that I have-
Goshala is also made party. I think.
Party, yes, that's point number 4. That Gaushala, my lord, is that Gaushala, police sent these cows to the Gaushala. I have no role to where the cows was kept. It is, my lord, the police has taken this. Now Gaushala is saying that they are taking they need the compensation from the government because they nourished this some period of time. So this is their concern, my lord. I being the owner, my lord, person to the order, this should be handed over. 13 numbers of cows, my lord. This is the case, my lord. So,
Mr. Ditul Das, my senior, he's not in the court today.
Ditul Das is appearing for Goshala.
Gaushala.
So we couldn't make a mention. So if court allows them any day, tomorrow, day after tomorrow.
No,
in
no, we
case
don't
we-
have any date before Bihu.
Okay, after we, no issue.
Your government advocate is. So you are for the respondent number 4.
4, yes, Lordship.
So if before Bihu, my
Because
lord,
government is required. Before Bihu, we don't have that. Before Bihu, we don't have that. Now you can see today is also 49 numbers of bail matters have been fixed, you see. So, you don't know what to do. Since morning, we're dictating the bail orders. Don't have any. Now after rising of, there are also lots of matters have been done. I have to see.
yes.
By 8 or say 8:30, I usually go home. Apart from that, it cannot be possible. It's not possible. Government advocate to Ahanan. Yes, shown in the cost list. Who was appearing, I don't know. So otherwise, everything is ready, it can be heard, na?
Yeah,
Finally.
can be heard. Everything.
I thought why it is in order column. In fact, they have also appeared.
Yes, ma'am. They appeared since long, ma'am.
Heard Mr. H.R. Chaudhary, the learned counsel for the petition. And also heard, yes,
No,
MS.
on behalf of D Das.
You are Mr. M.E.
Tinlung.
Acha. So and so appearing on behalf of Mr. D. Das for the respondent number 4. And she submitted that due to some personal inconvenience, Mr. Das is not in a position to appear before this court today. And in the same time, it is also seen that the government advocate, who is also a party to this case, is absent. Stop. Mr. Chaudhary submitted in this regard that this is a petition wherein they seeking custody of the cows which are still in possession of the respondent number 4. Let the let the matter be listed after Bihu, it will be listed.
22nd or 23rd, date may be fixed, my lord.
He is saying it can be on the month of May only.
Otherwise, my lord,
30 go to 30. 30th of April, 30 or 20. 11 matters are only there. 30 can be only. 30, 30.
You want?
This matter may come after Bihu vacation.
You are for the petitioner?
Yes, Lord.
And no one is representing the respondent.
Mr.
Government is there or what?
Yes, Lordship, government is there, but basically this is a grievance against the Otulota Limited. So Otulota Limited is represented by Mr. Osim Somua. Advocate Osim Somua.
Oh, earlier he appeared.
Yes, Lordship, his name was shown in the court.
Your lordship, it's item number 52 actually.
Okay. Huh? Actually, 2 items are there, 51 and 52. Oh, no.
No, 52 is Otoloto one.
Oh,
Here, your lordship, the petitioner has died last year, your lordship. The matter holds no ground.
no, Lordship, because this is not
Yes,
by the company.
by the company, but he was a representative, right? The company,
No, he is representing, no new representative will come because he was representing the company.
the company has already been dissolved, your lordship.
No, the company has not been dissolved. This is a wrong information.
Anyway, both the matters we will listing
Yes,
at after Bihu,
probably in the first week of May.
first week of May. So let it be on first week of May, both the matters. And now, what your information is there if the companies who died?
Actually,
petitioner
Lordship,
has
in the petitioner Eco Motors.
Petitioner in item number
52.
52. He died.
Yes.
So bring this information to an additional affidavit before this court. If in fact it is your information is correct regarding the dissolving of the company and all, so make it clear by affidavit in opposition,
Lordship, I
because
have
now
the clear
he is saying that still existing, it is not dissolved. So if it that be the position, then that will take.
The managing director of the company was Kumar Gaurav. He has expired, and thereafter the company is still subsisting because other directors are there. There is a dispute regarding the legacy of the Kumar Gaurav. So a dispute is there. That is a different civil case is pending. So company has not been dissolved. That is my instruction.
Okay. So
Okay,
if you
Lordship,
have any other
I'll-
instructions in that regard regarding the
They can-
dissolving of the company and also bring it on record, and regarding the date of so and so also bring it record, because he is saying that the other directors are still there and the company is still running.
But he was the petitioner here, your lordship. He was itself the petitioner.
Other one will represent because this is filed by the company.
So that is
Eco-Motors
up
and
to you,
Procedural.
if in his absence, whether any other person is interested to deal with the petition and all that, they will give us all these details, every detail on the next date of listing. This both the matters after বেলেগ order করবো বা জি করে in the first week of May, at the date to be fixed by the registry. First week of May.
Much.
Much obliged.
Yes, 51 and 52.
53 to 55.
Wow.
Respondent number 4, Guwahati High Court. These are the matter, my lord, there are 4 matter, my lord. Only one matter, my lord, that is WPC criminal 16 of 2024. And in
That
that
is
case,
item number 54.
no, item number 54, not my lord, that.
WPC criminal 16 is item number 54.
No, sorry. 15 of 2024, that was not here, my lord, I'm just Please, the
Oh, it's not here.
not here. There are four matters take together. I file a affidavit in that 15. That was the lead case, my lord. But after filing the affidavit, that was withdrawn. So, my lord, I have to file again, my lord, in other three cases, my lord. So, as I, on behalf of the Guwahati High Court, Respondent number 4, my lord, I want to file affidavit in these three cases also. They are challenging the jurisdiction of the, my lord, that special court.
Oh,
That Rakesh Pal matter.
Rakesh Pal matter, acha, acha.
So I file affidavit in one cases. So everything, my lord, stating everything, but ultimately that was been
That
withdrawn.
was withdrawn.
So now, my lord, that is already disposed of. So I have to file, my lord, case in this
See
thing, my lord.
now three
My lord.
matters.
So on behalf of the respondent number 4, my lord, I want 4 weeks time to file it.
So you are appearing for respondent number 4 from
Yes.
Guwahati High Court. Petitioner side, who is appearing
my lord.
there? Mr. S. Das is there, I think so. For the petitioner side. And the PP is also respondent. J. Assam is also there, no? Respondent 1. You are for 4, Guwahati High Court. None appears on call for the petitioners. I heard Mr. TJ Montam, so the senior advocate assisted by you. T. Gogol, appearing as a standing counsel Guwahati High Court for the respondent number 4. And accordingly, Mr. Mohanty submitted that he needs 4 weeks time to file his written affidavit in opposition. Also heard Mr. R.J. Borwa, the respondent number 1, representing the PP Assam. List accordingly after 4 weeks, enabling the respondent number 4 to file their affidavit in opposition. Okay, we are filing, fixing after 4 weeks. All the matters.
More than it?